All right. Good morning, everybody. I hope everyone is doing well. My name is Dana Sparks, and I am the director of the Georgia Real Estate Academy, which is the school offering this course for CE credit. I see a lot of familiar faces, so hello, and I see a lot of new faces. So welcome, welcome. Today's class is the 2022 GAR, Georgia Association of Realtors contract changes. Now, this is not a full-blown contracts class, fill in the blanks, how to do everything. This class is on the changes that the Georgia Association of Realtors has made to their contract package from 2021 to the new version 2022 that will be released January of 2022. I also am going to cover the mid-year changes. GAR always makes changes at the end of the year for a new release, and they always make changes in the middle of the year, anytime between April and May. This year they came out April 15th, tax day. And what happens is a lot of agents, especially a lot of experienced agents, never take another contracts class. So if one of those changes occurred in a form that you use, you will have seen the change. But if not, you might not be aware of that change. So in this class for the 2022 GAR changes, I am also going to address the changes that the Georgia Association of Realtors made mid-year of 2021. Hang on. Got to get my computer plugged in. So, nope, not be good if the computer goes out. So most of the changes, a lot of times the changes, actually, hang on one second. I got to plug in my computer so we don't lose it in the middle of class. All right, see if that worked. So a lot of the changes that GAR makes are sometimes just corrections on syntax errors or typographical errors or numbering errors or things like that. But every now and then there is something that has to do with the actual, something with a form that would be rather important for you to be aware of. So again, I will address those issues throughout this class. I do have handouts available. You do not need them right at this moment because that's what I'm going to do the class for. I'm not doing it as a PowerPoint. I am doing it as going through the handouts, and they are available. Let me put it in the chat one more time. If you go to www.eagentweb.com and select training videos, you will see the hyperlinks to those. And I'll pull that up again and I'll show you, walk you guys through that. So before we get started, in the chat section, please type in your name, your license number, your email address, and your phone number in case we have issues recording the credits. And we are going to get started. Any questions, go ahead and type those in the chat. And we are going to get started. So let me share my screen. And let me preface this class by saying, I think you guys will be excited. There's not a whole lot of changes, but there is enough for 3 hours of CE credits. 3-hour class and then some. A lot of the changes are in the buyer's brokerage agreement and not a ton in the purchase and sale, but you'll see as we go through. So let me share my screen and we will get started. All right. There we go. All right. All right, everybody. So the way, let me fix this just a little bit. All right. So the way I have the handouts for this class, and again, these are available for you guys to download. So I've got this one handout, which is the 2022 GAR contract changes. That's the cover page. The notice to students, actually, let me go ahead and read that. This is for the virtual broadcast or classroom class setting for a CE class of a GREC approved classroom class. The Georgia Real Estate Academy GREC School 6915 with the end date of renewal being next year, December 31st next year. It is the 2022 GAR contract changes. It is GREC course number 73595. It is a classroom virtual remote broadcast of an approved in-class course, 3 hours in duration, approved by GREC for CE credit. No prerequisites to receive credit. I'm the instructor. My name is Dana Sparks. I am not only the director of the Georgia Real Estate Academy, I am also the qualifying broker of Maximum One Greater Atlanta Realtors. There is not required homework and no written test. You must be present for the entire broadcast instruction hours in order to receive credit. And roll call and documentation will be done via the chat function. So I'm going to ask you guys 3 times now when you first log in, after we come back from break, and before you leave, to go ahead and type in the chat function your name, license number, email address. You don't have to type it in every time I mention it. As long as we get it in there, that would be great. And the questions too. You guys will see me turning my head to the side like this because I do have another computer where I can monitor the chat function. No recruitment for employment opportunities for any real estate brokerage firm is allowed in this class or on school premises. I'm not sure that is loosely defined in these Zoom classes. If so, please let me know, let GREC know, or Heidi Kelly is the coordinator of the school. There is her email address and her phone number. She is the one that does record the CE credits, and that those will be done within 1 to 5 business days. All right, and let me just make sure everyone is muted. All right. So as I started to say, so you guys have, and the way I'm going to teach it is this handout, and this is what we're going to cover. We're going to cover, let's see if I can make this bigger for you guys. There we go. We are going to cover an introduction, the purchase and changes to the purchase and sale agreement, the financing exhibits, disclosures, contingencies, brokerage agreements, miscellaneous forms, the lease, consumer brochures, and special stipulations. So in this handout, you get all of my notes and the notes on the changes. Then I also have, and these are again available for you guys to download. We're going to go through them. You also have the actual training documents with all of my underlines. So we're going to go a little bit back and forth. I felt it was easier to do this with the actual documents rather than with the through a PowerPoint where it's a little bit out of context. So let's start with a little bit of introduction into the Georgia Association of Realtors contracts. Their licensing agreement, if you are a realtor, you get access to the license to use the forms via your dues money. If you are not a realtor, you can always pay GAR for the license to use their forms, and the cost in 2022 is $254. They will be available online January 1st, and they're available through wherever you're accessing your forms now, whether it be Remind Docs through FMLS, Connect or Transaction Desk in Georgia MLS. If you go right to the Georgia Association of Realtors website or whatever MLS you are using, some of you guys have access to your forms via .loop. So I'm not sure for some of the vendors that are putting these forms, for example, like .loop, I'm not sure when they will have them up, but GAR has released them to these companies so they can make them available where you guys can access them. Part of the licensing agreement is once the 2022 forms are released, it is a GAR licensing violation to use any of the GAR forms with previous dates. Now, what does that mean? That doesn't mean you go back and redo a purchase and sale, a binding contract, or redo a listing agreement. If something is already signed, you don't have to go back and do it. What it does mean is if you're going to initiate a form moving forward, you have to use the 2022 forms. All right, who's authorized? If you're a realtor, then if you have paid your dues, then your part of your dues money goes towards the licensing to use the forms. If you have fulfilled your NAR Code of Ethics course, now we are ending cycle 6 this December 31st. So a brand new 3-year cycle, cycle 7, will begin January 1st of next year, and you have 3 years to complete that. If you have paid GAR to become an authorized user, you'll get a forms purchase ID number. And what are the other alternatives? If you are a co-op agent in a transaction, then you can use those. If your name has to be as one of the signature lines as a co-op. If you are if your broker has those forms, you cannot use your broker's form unless your broker has signed it. In other words, if that were the case, then GAR would only have to charge the actual brokers and not every agent. So that's what's going on there. There are other alternatives too. There are RE forms at no cost. You can go to the GAR website or NAR website. There is a GAR helpline for realtors because you do have to put in your NRDS number, and you can get that link through the GAR website. All right, generally speaking, again, they do make mid-year changes, and this class will cover both. And 1 new form and 3 new special steps this year. The new form is F733, the Binding Agreement Date Confirmation Amendment. We'll get into a good discussion about that. And the 3 new special steps. Special step 220, buyer warrants that the use of land will qualify for preferential tax treatment. We'll talk about that. Repairs made by a seller during a transaction. We'll talk about that. And seller consents to assignment of purchase and sale. We will talk about that for those of you working with investors. Additionally, GAR, a lot of agents, you may or may not know, GAR released a lot of special stipulations November of last year that are specific to the times we are in, and I have those written out at the end of this attachment. So here we go. Again, the way this works is here is a list of the changes, the pertinent changes, and my notes on this, and I also have the forms. So let's go right to the forms. Can you guys see those? Let me make this a little bit bigger. All right. I'm going to make that go away, and let's make this a little bit bigger. So this is a list of the 2021 GAR forms revision packages. These are the changes that were made in April of last year. Wherever you guys go to get your contracts, you can get this too. This document is going to go away in January. So if you want a copy of the changes that were made in April of last year, either you have it here in my handouts, or you need to go ahead and go log in to the GAR forms and you can download this document. I do have underlined some of the more substantial changes. Again, there's things where they corrected grammar or changed paragraph numbers or things like that. So again, I'm scrolling through this a little bit quickly because we are going to talk about these within the context of the actual form. And some of these were changed even further in 2022, but I just want to let you know that is there. Additionally, there is, I have it for the class, and starting in January, you will have a whole outline of everything that was changed in 2022 of the forms changes. This form I don't have underlined because that's the whole purpose of the class. But again, you'll see there's just some different subsection letter changes and things like that. But I do have this for you as a handout. All right, we are going, normally I keep this towards the end, but let's dive in. This is the most frequently used form. So let's go ahead and dive in and we'll go over the changes. As I said, there are not a ton of, can you download these right now? Yes, Vanessa, you can, but it is a gazillion pages, but you can download them. Again, let me put in the chat where you can access them. I'm going to send it to everyone. Towards the bottom of that, you don't have to repeat in your email and all that stuff, but towards the bottom, the handouts are available at www.eagentweb.com. It's just a website. You don't need to log in. You're going to select what looks like training videos and then scroll through for that class. Let me just show you. www.eagentweb.com. Oops. Select this tile right here where it says training videos. You are going to scroll through training videos and CE class handouts. This has video recordings of many of the CE classes we've taught, as well as handouts. First one, here it is, 2022 GAR contract changes. This is my contact information. Here are the handouts. So if you click on any of these hyperlinks, it pulls up the form and you can download it on your computer. So I tried to combine them and my PDF reader would not combine them into one form. So you've got this handout 0 is that document of the outline that I've been going through. And these handouts, they are all numbered in the order we are going to address them in class. There are 25 separate handouts that are the training versions of the GAR forms with my underlined notes. So that is where you can get to those. All right. On to the purchase and sale. So the first thing they did, they've rearranged these paragraphs a little bit, and you'll see, well, the first thing they did is they changed the title. It now says closing law firm rather than closing attorney / law firm. And they have put a phone number. For some of the law firms that have multiple offices throughout Metro Atlanta or Metro Georgia, throughout all of Georgia, they put a phone number there so that everybody can be on the same page and make sure that everybody shows up at the same office of that closing attorney. The other thing they did is they have rearranged these paragraphs. So now the holder of the earnest money is the paragraph right above where we talk about the form and the amount and the remittance protocol for that earnest money. Just a reminder, if the buyer and seller select a closing attorney as the holder, 5F10 is an exhibit and must be attached to the contract. And then after you are binding, the parties have 3 days to get the closing attorney's signature on F511. 511 is not an exhibit and is not signed by the buyer and seller. I'll go over that a little bit more when we get to changes in those forms. Now, the other thing they have done is under paragraph 8, the inspection and due diligence paragraph, they have added the word under option payment. So they've added two things. They've added that the payment goes directly to the seller, and they've added the option for ACH. So let's talk about this just for a brief moment. Due diligence period. I'm not going to go full blown like I do in a contracts class, but basically a due diligence period is the seller granting the buyer the option to terminate the contract within a certain amount of time and to not be penalized for terminating the contract within that time frame. Because it's basically what it is, it creates a little mini option contract within the broader context of the entire purchase and sale agreement. So because it's a separate little mini contract, you have to mention consideration or option money. That's what paragraph 1 is. It says that's just legalese that has to be in there because it's a separate, like I said, little mini option contract within the broader context of the purchase and sale agreement. But what can happen is a buyer can try to entice a seller in a competitive market to take their offer over a competitive buyer's offer. One of the ways to entice the seller to do that is to offer the seller additional option money for this due diligence period. That money is not earnest money. It is not trust money. It is money that goes directly from the buyer to the seller. And that has always been the case, but it got confusing. So GAR has added directly to the seller. Then you have the option, which you've always had. Does this additional option money, it is non-refundable. That's why it's an enticement to the seller to select this contract potentially over another buyer's contract. There is the option to negotiate if those funds do get applied towards the purchase price when it goes to closing. So again, they have added directly to the seller just for clarification purposes and ACH. So let's talk a little bit about ACH. You will see also up here in the earnest money that is a form of the earnest money. I'm telling you guys right now, a lot of brokerages and a lot of closing attorneys will not accept an ACH payment. That stands for Automated Clearinghouse. And basically what that means is the money comes directly from the person's checking account and goes into the holder's account. The reason why a lot of people will not accept ACH is because the sender of the ACH payment can undo it. They can rescind that ACH payment. As a matter of fact, the bank can rescind the ACH payment, and that can be done up to 60 days after it has been made. And the reason you're like, well, why on earth can a bank rescind it? Well, the bank can rescind it if, for example, the person gets overdrawn in their checking account. They can rescind the ACH to cover other checks written off of that account. So very interesting for that. All right. Then moving on for paragraph B, and this is a universal change that GAR has made, it used to just say corresponding paragraphs to section A. Now it says further explanations to the corresponding paragraphs. And one of the changes under the prorations portion that GAR made in April 15th of 2021 is they added the reminder that a property could also have city taxes, property taxes, in addition to any county property taxes. So they just added that the proration obligation between the parties extends not only to the county property taxes, but also to any city taxes if applicable. Now, in 2021, there is a change that they have made regarding the holder of the earnest money. And what they have done there is they've added this introductory sentence that says, the earnest money will be paid to the holder. This is what they've added in a method of payment acceptable to the holder. And again, the reason they had to put that in is because on the paragraph A, for example, they do have that ACH option or check, so forth and so on. But again, some might not accept ACH. Some might not accept a personal check, depending on the amount. Some might not accept a bank check, depending on the amount, so forth and so on. So they've added this caveat that the method of payment must be acceptable to the holder. And they've also added that if the holder has the right to charge the buyer for any costs associated with receiving earnest money. There could be bank fees associated with that for a wire or ACH, or if a check is not honored, let's say it was a personal check and it's not honored by the bank, then the holder can charge the buyer for those fees, and that charge would be in addition to whatever would be collected separately from the actual earnest money. So they've added that in 2021. Hope I'm not giving you guys, making you dizzy. All right, now we are down to the notice section. And let's talk a little bit about this. I don't know why this gets a bit confusing, but all right, hang on one second. I got to find my chat. Here we go. All right, here we go. Just want to make sure I'm not missing any chats. Use a wire if you want to make sure that once a wire is gone. Yes, that is very true. So better to pay in livestock. That way it can be easily rescinded. I'm not sure where the holder is going to secure the livestock in a safe place. But yes, wire, while we were talking about wires, just a comment on that. Why our industry is fraught with wire fraud, and it is the emails that are being hacked. So agents, y'all should never, ever, 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 ever email wire instructions. There's an admonition in the GAR contracts, and you should all have it as a footer in your business emails that a buyer will net, or even a seller too, because sometimes the seller has to needs wire instructions for payoff information, so forth and so on. But you should never email wire instructions. They should either be delivered over the phone, making sure you're talking to the proper person, or by US mail. Even some of the closing attorneys have double and triple and quadruple authentication, or you can hand the wire instructions to your clients. But it's the emails that are being hacked. And as an agent, never be the messenger, so to speak, to even email the wire instructions from a closing attorney to one of the parties. Once a wire is gone, it is gone. It's not like a credit card charge that you can dispute. It is gone. Also, you guys, the bad guys are getting really clever, and they are texting clients. They're mimicking your text number, your phone number, or an attorney's phone number, and they are texting a change in wire instructions. So just make sure your public people know to triple confirm the wire instructions from a third-party source other than where they got the wire instructions. All right, so delivery of notice. So basically, in the case of notice sent electronically, which would be fax or email, per the GAR contract, notice is deemed received by the recipient when the sender can prove they sent it. That has always been, well, it hasn't always been the case, but it's been the case for the past couple of years in the GAR contract. It says that basically, if I am sending notice on behalf of my buyer, let's say it's a termination, let's say I'm on the last day of my due diligence period, and I have until 11:59 p.m. tonight to send notice of termination to the seller. Let's say I send that notice of termination signed by the buyer at 11:58 p.m. on the last day of due diligence. I hit send. I can prove in my email the date and the time it was sent. Let's say you are the agent and you represent the seller. You don't get that email. You don't open that email until tomorrow. Tomorrow would be a day after the expiration of the due diligence period. It doesn't matter when you open it or when you receive it. It is deemed received when the sender, in my example, me, I can prove I sent it at 11:58 p.m. the last day of due diligence. So I have protected the buyer's earnest money by terminating and sending notice of termination before the expiration of that contingency. So that has always been the case, but for clarification, for a couple years, but for clarification purposes, GAR added even if not opened by the recipient. Then further on, when is a broker authorized to accept notice to on behalf of a client? And it says they have added the sentence this year: authorized agents of the party for the limited purpose of receiving notice. And even, again, they've added that thing, even if it's not opened by the recipient. So in other words, I am not, you guys as agents, you are not a party to the contract, but you can send and receive notices. You have the limited authority to send and receive notices, whether you're working for the person as a client or but you're not, you can't bind the party to terms, but you can send and receive notice. And it says even if not opened by the recipient. There is a chat question about cryptocurrency. And I believe that actually might be one of the reasons why GAR added the information, that pre-sentence in the earnest money paragraph that states the earnest money will be paid in a method of payment acceptable to the holder. So the holder might not accept cryptocurrency. While we're on this topic, you guys be really careful with electronic sending of money through these apps like Zelle or Cash App or something like that. You need to check with the holder to see if they accept that. One thing you may not do is, you as the agent may not have a public person send you money via an app like Zelle or Cash App, and then you turn it into the holder. That is commingling of funds and a license law violation. Now, as far as notice, Clarissa, I will get to this a little bit more when I get no authority to bind, but agent to agent communication, agent to agent email does not constitute notice. So for example, back to my example, let's say I'm working with a buyer. The buyer is going to terminate the contract based on due diligence. I find that out that day of due diligence. I cannot just send an email to the seller's agent saying, hey, my buyer's going to terminate under due diligence. Agent to agent email does not constitute notice. It must be done in writing, and this is not a change, but under paragraph C1A of notices, it must be done in writing, legible, and signed by the party giving notice. So it needs the buyer or seller's signature. Agent to agent. Agents, you guys are not parties to the contract, just your public buyer and public seller. So your email communication with another agent does not constitute notice. All right, moving along. Here we go. No authority to bind. Basically, you as the agent nor your broker, you cannot say what your buyer or seller are or are not going to do. Whatever communication you give to that does not mean they are going to do that. Any communication that would bind the party to terms, make them be responsible and have consequences for what they say they are or are not going to do, must be done with their signature. And it says no broker affiliate licensee by virtue of this status, you're not a party to the contract, have the authority to bind to anything in the contract, amendments, termination, or to notices signed by the broker, but not the party. So you cannot just send the TNR if it is not signed by the buyer. I mean, you can send it, but the buyer would not have fulfilled their obligation. And then it says, but not send notices from the broker on behalf of the party unless signed by the party. It further goes on to say, we're talking about a dispute over the binding agreement date. And hang on. Okay, there we go. What it goes on to say, I don't know why agents still have disputes over the binding agreement date. I am not sure. I'm not sure. I don't know why. But basically, there have been a lot of disputes over the binding agreement date, and it's important. The binding agreement date is important because that is the date from which all of the contingency timeframes are timed. And for purposes of counting, the binding agreement date is day 0. So if you have a 5-day due diligence period, let's say, and today is 12/8/21. So if you go binding today, the 8th is day 0. The 9th is day 1. The 10th is day 2. The 11th is day 3. The 12th is day 4. The 13th is day 5. The buyer would have until 11:59 p.m. on December 13th. That's the end of that contingency time frame. So the problem is the binding agreement date is sometimes the other party is filling it in. If you're filling it in on the same day, it doesn't matter. The date is what is the important thing. The problem is, let's say we go binding and the binding agreement date, let's say I'm the buyer. I write an offer to the seller. The seller writes a counter offer to the buyer. The buyer writes a counter offer to the seller. The seller now signs and accepts the terms. That is not binding. It is not binding until the seller sends it back to the buyer. Then we have a binding agreement. So on one hand, you have a contract that has all signatures. That is an accepted agreement, but is not yet binding on the terms. I could withdraw that offer. I could withdraw my last counter offer, even though the seller has signed it, if I do not get that signed copy back. It is not signed. So the easiest way to think about it is the party that makes the last offer or counter offer. In my example, I was the one to make the last counter offer. That party is the one that binds the contract. So the seller is going to have, the listing agent is going to have a contract with all signatures. They send it back to me, and I am the one that binds the contract. The binding agreement date is the date that the party making the last offer or counter offer receives it back with all the signatures. So it gets confusing because what happens is that listing agent will fill in the binding agreement date, or the seller will fill in the binding agreement date and send it. If it's the same day, it's the same day. If they don't send it till the next day, they're going to fill, let's say they send it, let's say I'm the buyer's agent, I send a counter offer to the seller. Let's say I do it tonight, the 8th, and I send it at 10 p.m. Let's say the sellers sign it at 10:30 p.m. But the listing, and they send it back to the listing agent. The listing agent goes to bed, doesn't get it back from the sellers, and doesn't send it back to me until tomorrow, December 9th. The binding agreement date would be December 9th, even though the sellers signed it on December 8th. So the confusion comes in because let's say the listing agent put in December 8th when their seller signed it, but didn't send it back to me until tomorrow, the 9th. The actual binding agreement date is the 9th. Well, that's going to be an issue if my buyers end up terminating under due diligence. The seller might think due diligence ends a day earlier than it actually ends. So it is an important issue, even though it can be clearly determined. So for 2021, GAR has added under notice of binding agreement date, notwithstanding any other provision to the contrary contained in this agreement, it is the express intent of this section that number 1, the broker or licensee involved in the real estate transaction may perform the ministerial act of filling in the binding agreement date, and number 2, sending a fully signed purchase and sale agreement with a specific binding agreement date included that one of the parties has agreed to constitutes notice of the binding agreement date to the other party. Then they have added a whole new subparagraph, subparagraph K. Objection to the binding agreement date. If the buyer or seller objects to the date entered as the binding agreement date, then within 1 day from receiving notice of the binding agreement date, the party objecting shall send notice of the objection to the other party. The objection shall be resolved by the written amendment between the buyer and seller by executing a binding agreement date confirmation. That is a brand new form F733, and I'll show you that in a little bit. The absence of an agreement on the binding agreement date shall not render this agreement unenforceable. The failure of a party to object will result in the parties accepting the binding agreement date as entered. All right. And further, it went on to say, I think it's in another section. It goes on to say, if there's still an ongoing objection regarding the binding agreement date, how does it get resolved? It gets resolved by the holder of the earnest money or by an arbitrator, but that's a little bit later on. So a contract cannot be accepted after the contract expiration date, but can become binding after the expiration date. No, that has to do with the time limit. It must be accepted. Does the agent need to bind it and send the other party before the expiration date time? Agent can receive tonight, wait till the next day to make that acceptance. Okay, you guys are all getting into a discussion of the time limit of the offer. And I cover that in the other contracts class. This is really, we've got to get to all the changes. But I will just, I'm not going to go through examples, but I will just briefly say, no, a contract must be, it is only open for acceptance through the time limit of the contract. So we'll get into a further discussion of that either later if I've got time, or else you'll need to take the other contracts class we teach starting in March, which will be 2022 GAR contract dissection. But we've got to get to the actual changes in this class. All right, brand new paragraph, or you guys can contact me after class and go through that. Brand new paragraph, paragraph L, rules for interpreting this agreement. And basically what this is an explanation of the hierarchy of control over what is in a contract. So it states, in the event of an internal conflicts or inconsistencies in this agreement, the following rules for how those conflicts or inconsistencies shall be resolved will apply. Number 1, Handwritten changes shall control over pre-printed or typed provisions. Number 2, exhibits shall control over the main body of the agreement. Number 3, special stipulations control or take precedence or supersede over both exhibits and the main body of the agreement. And number 4, notwithstanding any of the above, any amendatory clause in an FHA or VA exhibit, and the amendatory clause is the appraisal clause, or the appraisal, we like to think of it as the appraisal contingency. It is a statement that the FHA or VA appraiser must appraise the property for an FHA. It has a fill in the blank, buyer and seller negotiate that price. And in the VA exhibit, it says reasonable value as determined by the VA. That amendatory clause or appraisal clause in an FHA or VA exhibit shall control over inconsistent or conflicting provisions contained in a special stipulation, another exhibit, or the main body of this agreement. In other words, very popular right now is this appraisal gap, well, not the appraisal gap stipulation, but forfeiting of appraisal or appraisal gap stipulation, or basically buyers are going into contract saying that I'm still going to purchase it, and I forfeit any earnest money protection, even if it doesn't appraise for sale price. I don't care what special stipulation you guys write. If the buyer is getting an FHA or VA insured loan and the property does not appraise for the sale price, then the buyer may terminate the contract and will get their earnest money back, regardless of any special stipulation written to the contrary, stating that the earnest money is non-refundable should the property not appraise, blah, blah, blah. They have an FHA and VA insured buyer. They are protected. Their earnest money is protected if the appraisal comes in low, and they have termination rights to terminate under a low appraisal with those loans through day of closing. All right, moving along, under the survival of the agreement, GAR has added last year, one of the mid changes they made in 2021 is they've added the section on attorney's fees. That basically, if there is any litigation regarding anything regarding the contract, any provision regarding attorney's fees shall be owed that survives the contract, obviously, because a contract is going to go to litigation if it is after the termination of the contract. So they've just added that in there. Now, GAR, thank you, GAR. They have added the definition of a day. So they've done this alphabetically, and when we took this class, everybody was suggesting that GAR put day down here, subparagraph E first, but they have it alphabetically. So we said, we'll put it a day, so it would come first. But regardless, I'm down here on subparagraph E, the definition of a day. For the purposes of this agreement, the term day shall mean a full calendar day ending at 11:59 p.m., except as may be provided elsewhere herein. For the purposes of counting days for determining deadlines, the specific date referenced as either the binding agreement date or date from which the deadline shall be counted will be day 0. For any of you guys that have been in any of my contracts classes or watched any of my videos on YouTube, Real Estate Made Crystal Clear, you guys constantly hear me say the party has till 11:59 p.m. at night. When it says day, that is the definition. So GAR has just clarified it for 2022 by specifically writing in there that a day is a full calendar day that does end at 11:59 p.m. Now, where it says except as may be provided for elsewhere herein, there is nothing to prevent a buyer and a seller for putting a time limit on a contingency. For example, this contingency shall end at 6 p.m. on the day that is 10 days after binding agreement date, something like that. So if the buyer and seller agree to that as a special stipulation, that would prevail. But because we just read, a stipulation supersedes the body of the purchase sale agreement. But if not, it goes through 1159. Now, what about a banking day? A banking day shall mean a day on which a bank is open to the public for carrying out substantially all of its banking functions. For purposes herein, a banking day shall mean Monday through Friday, excluding federal holidays. Well, you guys are saying, wait a minute, Dana, my bank's open on Saturday. There's a lot of banks open on Saturday. I'm going to count Saturday as a banking day. No, Saturday is not a banking day. There are many banks that are open for consumer convenience on Saturdays, but there is no money changing hands between institutions or at the federal level. Saturday is not considered a banking day. Now let's look at business day. And again, there's confusion over this. There are a lot of businesses, for example, that are not open on Mondays, or there are certain holidays where one real estate brokerage might be closed for that day. So a business day can be confusing too. So GAR has defined for 2022, a business day shall mean a day on which substantially all businesses are open for business. For all purposes herein, a business day shall mean Monday through Friday, excluding federal holidays. In essence, for the purposes of the GAR contract, a business day and a banking day refer to the exact same thing. Then under exhibits and addenda, there used to be a statement that stated exhibits shall control over the body of the contract, and special stipulations shall control over, there it is under special steps, shall control over exhibits and addenda. All of that hierarchy language, as I just went over, is now in paragraph C4K, so they've removed it from there. And then they have always had additional special stipulations. They just added a form number to the referenced additional page. So that's it for the purchase and sale agreement. So now let's move on. There are all my notes on that. Now let's talk about the land purchase and sale agreement. So I just want to bring this to your attention. You may or may not deal with land, but this is really important. If you do deal with land, there is a lot of money involved in some of these issues. And this, there we go. This change also does show up in the seller's property disclosure form. All right, turn in money. A question: to turn in earnest money, should it be 3 business days? That the term for earnest money, that is negotiated between a buyer and a seller, and it does just say days, blank days from the binding agreement date. So that would be a calendar day through 11:59 p.m. Your broker, if you are a broker, might have a policy on that, but in the purchase and sale agreement, earnest money, it is days, so it goes through 11:59 p.m. All right, the land agreement. Again, there are a lot of the same universal changes throughout all the purchase and sale agreements: closing law firm, that verbiage, phone number, additional option money directly to the seller, ACH, so forth and so on. But here is what I want to get to. This is the main difference, and this is really important financially for your buyers and sellers dealing with land. They have added under the prorations, this last paragraph, I'm on the land purchase and sale agreement. It states, in addition, this is the proration of the property taxes and fees and so forth and so on. In addition, if buyers change in the ownership or use of the property, will result in rollback taxes being owed because preferential tax treatment of the property for agricultural purposes can no longer be received, then the seller shall be solely responsible for the payment. The seller now shall be solely responsible for the payment of all rollback taxes at closing. Notwithstanding the above, in the event the buyer warrants to the seller herein that the buyer's use or ownership of the property will qualify for a continuation of the preferential tax treatment of the property as agricultural property, and the buyer is found to no longer qualify for the same, then the buyer shall indemnify and hold the seller harmless from and against all liability for rollback taxes. Okay, what on earth is this all about, and why is this in here? Basically, there is a conservation easement, or what's called conservation use value assessment, or CUVA is the acronym. A conservation easement is a voluntary legal agreement between a landowner and an easement holder, by which the landowner imposes permanent restrictions on the way the property is used. The Georgia Conservation Tax Credit Program provides conservation tax credits to donors of conservation easements. The Georgia tax credit is a financial incentive for landowners to help protect Georgia's natural resources. So the conservation use value assessment, or you'll hear it referred to as CUVA, for Georgia, you guys, that is a 10-year covenant or agreement where the landowner pledges to maintain the land in a qualifying use in exchange for property tax value based on the land's productivity, not the fair market of the land. If you break this covenant, for example, develop the land, the owner pays retroactive taxes. In other words, you, somebody that owns land, they might have a deal with the government where they're getting a tax break for the promise for 10 years to not develop that land, and it's maintained for agricultural purposes. They then go to sell the land. If they sell the land and it changes, like they sell it to a developer, the seller, they're going to change they're going to develop it rather than maintain it as agricultural. The seller at closing will owe all back taxes going back from when they started it, and it could be up to 10 years at closing. If, however, the buyer says, I want to buy your land, I promise to keep it agricultural until the end of this 10-year covenant, then I'm going to develop it. The buyer buys it, seller sells it. Then 2 years into it, let's say the buyer changes it and says, well, money's too good, I got to develop it into a subdivision, but we're not through that 10-year. At that point, the buyer then has to pay the back taxes going back from the beginning of this conservation easement to the government. So you listing agents selling land, you absolutely, to protect your seller's financial interests, you have got to use this. If they do own the land with CUVA, with this conservation easement tax break, you have got to include this brand new special stipulation. Buyer warrants that use of land will qualify for preferential tax treatment. And I do have that. Okay, hang on, I'm gonna make you dizzy for a minute. I do have that special stipulation here in your package. And it just says buyer warrants that the use of the property will continue for preferential tax treatment, so forth and so on. Again, that will prevent your seller from having to pay all those back taxes at closing. All right. There is information about that also in the seller's property disclosure form that you'll see. So basically, that's the biggest change to the land purchase and sale agreement. All the other changes are consistent with the universal changes in purchase and sale. All right, moving along to the cash exhibit. All cash exhibit. Basically, what GAR has done under the appraisal contingency paragraph, does the seller need to disclose this information? Yes, the seller would, if a seller is selling land and it is under that conservation tax easement and they are getting a tax break, you absolutely would want to disclose that to a buyer, because you don't want a buyer buying land thinking they can turn it into a subdivision and then incur tax break if the seller has disclosed that. So yeah, very important point. You would want to disclose that. Okay, under the cash exhibit, financing contingency exhibit, under the appraisal, there is the appraiser. The term certified appraiser and independent appraisal assignment is defined in Georgia law under OCGA 43-39A-2 and -224. So GAR has just made reference to the law where it says that appraisal shall be a quote certified appraisal of the property as that term is defined, and it references the law. And then further down it says independent appraisal assignment as that term is defined. So they've just added the reference to the law where that is regarding an appraisal on a cash deal. All right, you guys, moving along to the financing contingencies. Not a lot of changes there. They have added a couple of things. Okay, we're going to talk about the conventional loan contingency, FHA loan contingency, and a VA loan contingency. So let's start with the conventional. Under the conventional loan contingency exhibit, and this is F404. This is the paragraph about the loan denial letter. So basically, seller says, okay, buyer, I'm giving you X number of days, your financing contingency period, to convince a lender to lend you the money. If you cannot do that, then you have to send notice of termination before 11:59 p.m., because it just says day, on the day that is whatever this time frame is negotiated, 14 days, 21 days, whatever, from the binding agreement date. And you then have 7 days after you send that notice to prove it. You have to send you have to terminate with me, the seller, before this negotiated time frame is up. After you send that notice, you have 7 days to prove it with a loan denial letter from the lender. Now, that loan denial letter must be a termination of this loan that's described up here. It must be a letter from this approved mortgage lender if one is named. If there's nobody named here, it can be from any mortgage lender licensed to do business in Georgia. And that loan denial letter has to be specifically a loan denial based on underwriting criteria. The loan denial letter, this subparagraph here, basically states that the reason the lender is denying you, the buyer, the loan cannot be based solely on one or more of the following. If the loan denial letter has this as the reason for the denial, it's going to be salt to the wound for the buyer. No, you're going to have to terminate the contract. You're not going to get the house, but your earnest money is not protected. Yep, you're getting turned down for the loan, and you terminated within the time frame, and you sent the loan denial letter, but it's very specific what cannot be in that loan denial letter. And in 2022, there are 2 more items that cannot be reasons that the lender is denying the loan, and you will lose your earnest money because you are not protected if this is the reason the lender is denying the loan. So all that, this has been in there, and it says, notwithstanding any provision to the contrary, the loan denial letter may not be based solely on one or more of the following. Buyer lacking sufficient funds other than the amount of the loan to close. If the buyer doesn't have cash for closing costs or down payment, nope, not going to get your loan, but you're also not going to get your earnest money back. B, buyer not having leased or sold other real property unless that contingency was agreed upon between the buyer and the seller as a contingency in this contract. C, buyer not having provided the lender in a timely fashion with all information required by the lender, including but not limited to loan docs, official wood infestation reports, structural letters, well test, septic, floodplain certifications, so forth and so on. D, buyer making purchases that adversely affect buyer's debt to income ratio. In other words, buyer, you went out and took advantage of all of these sales to buy a whole house full of furniture, or you went and bought a new car. now your debt to income ratio has changed from the time you applied for the loan. I can't give you the loan. Nope, you're going to get turned down from the loan, but you're also going to lose your earnest money because you do not meet the terms of the financing contingency protection. Okay, so here's what they've added for 2022. E, the property not appraising for at least the purchase price unless this agreement is subject to an appraisal contingency and an appraisal meeting the requirements of this agreement has been performed. And F, the lender not having completed underwriting loan request. So here's the issue why this came up. A lot of agents confuse the appraisal contingency versus a financing contingency, number one. And a lot of buyers are terminating under a financing contingency if the property didn't appraise for sale price. That has nothing to do with the financing contingency. That has to do with the appraisal contingency, and there's different time frames for that. But so basically what this is added is the loan denial letter. If it has information about the appraisal in there, then it doesn't fit under the financing contingency. Even if that's on the loan denial letter, that has to do protection for that buyer would be under the appraisal contingency. Additionally, we've had buyers terminating contracts when they've waived their right to an appraisal, and an appraisal has never been done. Well, you can't terminate and protect your earnest money if the under this situation, if the appraisal hasn't even been done yet. So that's why they have added that in there. So that's it for changes on the conventional. For changes under the FHA exhibit, that same the verbiage about the appraisal contingency, you'll notice is not in there because of what I just said, what I said earlier. The amendatory clause paragraph, I'm on the FHA loan exhibit now, is the appraisal paragraph. An FHA insured buyer has protection for their earnest money if the property does not appraise for whatever dollar amount buyer and seller negotiate here. They will get their earnest money back if they send notice of termination based on this reason prior to 11:59 p.m. at night on the day of closing. So this loan denial letter, the new changes, they don't include anything about the appraisal because an FHA buyer of the appraisal, they are protected on a low appraisal. But they did include lender not having completed underwriting the loan request. And on the VA loan contingency exhibit for 2022 changes, again, they don't have information on this loan denial letter information about the appraisal because, again, paragraph 11, the amendatory clause, in essence, is the appraisal contingency protection for a VA insured buyer. No fill in the blank for a dollar amount. It just must appraise for what is considered reasonable value as established by the VA. If it does not, a VA insured buyer may terminate by sending notice of termination to the seller before 11:59 p.m. on the day of closing, and they will get their earnest money back. But they did add that subparagraph E. And additionally, under the VA loan contingency exhibit, under the certain repairs made for by the seller, again, buyer and seller negotiate that if the VA appraiser mandates repairs, how much the seller will pay, as long as the seller will do them, as long as they don't exceed X amount of dollars. Well, what if the repairs do exceed that dollar amount negotiated between the buyer and the seller? It says seller or buyer shall have the option to pay the excess amount. If the parties do not agree in writing who shall pay the excess amount, then this agreement shall terminate within 3 days of written notice of the itemized estimate, and the buyer shall be entitled to return of the earnest money. So a couple of different changes in the VA loan contingency exhibit. All right. Moving along to the seller's property disclosure statement. In mid-year of 2021, under the instructions to the seller for completing this statement, they did add that the seller, if they mark yes to an answer, are to provide additional explanation. And they did add, including providing to buyer any additional documentation in the seller's possession. So that was a mid-year change last year. You buyer's agents, you need to make sure to get that. Now, just a comment here under paragraph 5 under the systems and components. A lot of agents continue, correct, if the property sends notice, they can receive. Okay, the question, before I move on to this, the question is, so this only applies to VA and FHA, correct? If the property sends notice, they can receive their, properly send notice, they can receive their earnest money back. Yes, okay, let me go back to this before I move on. Conventional loan. Buyer and seller are getting a conventional loan. Under the, I'm sorry, obviously the seller is not getting one. The buyer is getting a conventional loan. In the conventional loan contingency exhibit, under the appraisal contingency, buyer and seller negotiate a number of days. The buyer is responsible for making sure that an appraisal is done of the property before that time frame. If the property does not appraise for the sale price, the buyer, before 11:59 p.m. at night, that is this number of days from the binding agreement date, is required to give the seller the opportunity to sell the house for the lower price. So they have to send an amendment to the sale price along with a copy of the appraisal. That time frame is not a termination time frame. This time frame is only a time frame by which the buyer must send the amendment to the seller, asking them if they'll sell the price for the lower price, lower than the contract price, based on the appraisal with a copy of the appraisal. Then the seller has 3 days from that date to say, sure, I'll do it for that and sign the amendment, or say, no, I'm not going to sell it for anything lower than the contract price. If the seller says, no, I'm not selling it for anything lower than the contract price, but the appraisal price came in low, the buyer has the option of bringing cash for the difference or terminating and getting their earnest money back, as long as it is, you have to look at these time frames here, and I've done a whole video on this. This negotiated time frame is to send an amendment, not to terminate. The seller then has 3 days to make a decision. The buyer then has 3 days after the seller's 3 days to make a decision. That's conventional. If the buyer does not do this process, the buyer can terminate, but they will lose their earnest money. This is the process to protect a buyer's earnest money should a property not appraise for sale price. Just a quick comment about these appraisal gap stipulations you guys are using. These appraisal gap stipulations are basically saying buyer will bring X amount of dollars over appraisal value not to exceed sale price. Number one, the buyer always has that option. You don't need a special stipulation for a buyer to pay more than the appraisal to meet the terms of the contract. It's an incentive to help a seller choose your buyer's contract over a competitive offer if you're telling the seller in advance that you're going to do it, but it's not, but you always have the right to do that. But nothing in those appraisal gap stipulations, if the gap is bigger, let's say you're under contract for $300,000. Let's say the buyer says, has a stipulation, they're going to bring $5,000 more than the appraisal price. Let's say the appraisal comes in at $250,000. Well, with that special stipulation, your buyer is going to bring $255,000, but you're still short of the sale price, the contract price. There's nothing that obligates the seller to come down to that lower amount. So just wanted to bring that to your attention. So that's how the appraisal works in a conventional loan. In the FHA and VA loan, we've already covered that. All right, moving back. Let me check my computer again. It is not staying plugged in for whatever reason. So hang on. Nope, that's not working. All right, I got one more option. There we go. Nope, I don't know why this isn't working. All right. Under the systems and components, everybody keeps saying, hey GAR, we need you to add an age to the HVAC system. Well, the issue is they're not going to do that because the problem is an HVAC is made up of a variety of components. There's compressors and fans and all sorts of things. So it's hard to put an age on the HVAC system, but they do have a date that the HVAC system was last actually serviced. And then under H, systems and components, it used to say solar systems. And yeah, I don't think they meant the universe and various solar systems. So they switched it to now say alternate energy source systems. Additionally, under the plumbing issues, they put is the drinking water from a well, and they added in date of testing. It's been from a well, but they've added date of testing of the well. And another thing that they put in mid-year last year is it has information if there is a shared driveway or alleyway. You need to disclose that because the parties will need to check on any easements that have to do with that shared driveway, alleyway, or private road. You know, are there easements, are there deeds regarding that, or will deeds need to be executed at closing regarding any of that shared property for ingress and egress into a property. And then under the termite section, they have added, they just broadened it out to basically encompass any types of critters or varmints. And it just says, are you aware of any wildlife accessing the attic or other interior portions of the residence? I believe that is all the changes. No, okay. Under the agricultural disclosure, they have added, is the property receiving preferential tax treatment as an agricultural property? And then they've added this whole subparagraph. It is the policy of the state and community to conserve, protect, and encourage the development and improvement of farm and forest land for the production of food, fiber, and other products, and also for its natural and environmental value. Basically, this is information that we have already covered regarding the conservation easement use. And not only that, it is an admonition. Actually, I take that back. It is also an admonition to a buyer buying in that property. This notice is to inform prospective property owners or other persons or entities leasing or acquiring an interest in real property that property in which they are about to acquire an interest lies within, partially within, or adjacent to an area zone used or identified for farm or forest activities, and that farm and forest activities occur in the area. Such farm and forest activities may include intensive operations that cause discomfort and inconveniences that involve but are not limited to noise, odor, fumes, dust, smoke, insects, operations of machinery during any 24-hour period, storage and disposal of manure, and the application of spraying or otherwise of chemical fertilizers, soil amendments, herbicides, pesticides. One or more of these inconveniences may occur as the result of farm or forest activities, which are in conformance with existing laws and regulations and accepted customs and standards. And now that is it for the property disclosure. Now this form, which was a brand new form last year, seller's disclosure of latent latent defects and fixtures checklist. This was initially intended to be used for non-occupant owners to have the opportunity to disclose latent material defects and disclose what items were staying with the property. However, since it's only 2 pages, a lot of owner occupants ended up wanting to use this rather than the longer seller's property disclosure form that we just went over. So because that is how it ended up being actually used, the in mid-year last year in April, GAR added a couple of checklists for disclosure purposes, so everybody was on the same page. So the first thing they did was under paragraph 1, they added paragraph 1, seller occupancy. And it is a checklist. The seller occupies or was the most recent occupant of a property. Seller was not the most recent occupant of a property, or seller has never occupied the property. That way, again, the buyer, prospective buyer, has more information regarding the seller's knowledge of that property. For example, was it a rental property? Did a seller inherit it? Is it a seller administering an estate that's selling the property? So forth and so on. And then number 2, seller hereby notifies the known latent defects. And they've added a checklist, no known latent defects, or here are the known latent defects. So those changes were made mid-year last year. Okay, I think we are plugged in now. And they should mention whether polybutylene is in the house or the yard. Have a date for the compressor component, since that's the most expensive part. Also expand for up to 4 systems. Great suggestions. I will make those suggestions to GAR, especially about the multiple HVAC systems, because in some of these larger houses, you are correct. There are multiple systems, and polybutylene. Yeah, well, we've got lots of defective products. Polybutylene, LP siding, Atlas chalet shingles, all kinds of things. Should every house come with a disclosure? So that's a great question. Should every house for sale come with a disclosure? It is completely up to a seller to choose to fill out a disclosure or not. They're under the Georgia fraud laws. They are required, and here is the reference to that law. It is, I don't know it off the top of my head. Maybe it's in the seller's property disclosure. It is required in Georgia that a seller disclose latent material defects of which they have knowledge that a buyer may not determine of their own. You know what? It used to be in here. It looks like they took it out. I would have to look up, but there is Georgia law regarding what they are required to disclose. Interesting, they took it out. But a seller, if a seller has no known latent defects, there's nothing they are required to fill out regarding anything regarding the house. Now, you listing agents, however, when a seller does fill out a seller's brokerage agreement, the seller does say that they will fill out a seller's property disclosure statement within so much time. So you listing agents, if the seller is not going to fill out a property disclosure statement, you need to address that in the listing agreement. But no, there is nothing requiring them to fill that out. It's in the new latent defect. That's what I thought it was there. All right. Anyway, there is a reference to the law. It is under the Georgia fraud laws regarding a seller being required to disclose that. Okay, lead-based paint disclosure. I do not have a handout of this in your package. Basically, it is the exact same disclosure as is available by the EPA. You can go to epa.gov to get a copy of that, or it is in the GAR package. It is the exact form. However, they've added brokerage lines. And just a note, you listing agents, if the house was built prior to 1978, you have got to have your sellers fill out a lead-based paint disclosure at the time of listing. Errors, incorrect signatures, dates, missing information, or initials on the lead-based paint disclosure can result in fines. You guys, the current fine is $16,000 per instance. Additionally, a seller, lessor, or agent, this goes for leases too, y'all, who fails to give the proper disclosure information, this is can be sued for triple the amount of damages. In addition, they may be subject to civil and criminal penalties. And I have a link in here for the enforcement information regarding lead-based paint violations. So you listing agents, if the house was built prior to 78, which you will know before going on a listing appointment, bring a lead-based paint disclosure form with you, have them fill it out while you are there on your appointment. You buyer's agents, before your buyer ever goes under contract, actually ever makes an offer, they are required to have a copy of the lead-based paint disclosure, as well as a copy of the lead-based paint consumer brochure, which is available through GAR or through EPA.gov. All right. Let's take a break, and when we come back, we're going to do the community association. Let's see, what do we have left? Let's do, yeah, let's take a break. You guys want to take a break? Top of the form. Thank you. I thought I'm going crazy. Oh, that's community association. I don't see it, but I know it's in here somewhere. All right. Yeah, you know what? Let's take a break. I think we'll take a break, and then we will come over the community. We'll start up with the community association disclosure exhibit and the rest of the class. So how we doing? So far, so good? All right, everybody, come back in 15 minutes. When you do come back, type in once again your name, your license number, email address, and a phone number. I have a 10. We'll just come back and hang on. Let me do this. All right. All right, everybody. So welcome back. Welcome back to the 2022 GAR Contract Changes, Georgia Association of Realtors Contract Changes class. And we are going to continue on. Again, I do have the link for the handouts, and I will say after class to answer as many questions as possible. If you guys are just absolutely loving this class and you know of some of your colleagues who were not able to attend today, the Georgia Real Estate Academy will continue to offer this class, 2022 GAR Changes, virtually, as well as hosted by Maximum One Realty offices throughout Metro Atlanta. And I will link the calendar below. We have several more classes that we are teaching throughout December. We will continue to teach them in January and February, and then probably around March. We're not going to teach this class anymore, but we are going to teach a full-blown contracts class called the 2022 GAR Contract Dissection, which is a full-blown going through the entire purchase and sale agreement, all of the financing contingencies, the commonly used exhibits, amendments, a more immersive actual contracts class. The purpose of this class that, again, we are going to teach through February is just the changes that GAR made from 2021, as well as we teach other classes as well. You realtors, you guys have till December 31st to take your ethics class to fulfill your NAR membership requirement. The ethics class has nothing to do with GREC, has nothing to do with your Georgia license. It has everything to do with your NAR membership if you are a realtor. If you have already taken it from January 1, 2019, you don't need to retake it again. NAR is on a 3-year ethics cycle, which will start again in January. So, all right. Public service announcements done. Let's continue on. All right, so we are done with that. And where we are now is we're going to finish up with the community, or we're going to start and do the community association disclosure, and then we'll get into the brokerage engagements and us and the rest. Okay, this is our favorite, the community association disclosure, everyone's favorite form. This year has undergone drastic changes on one hand and no changes on the other hand. So let me mute everybody. So the drastic change that happened was a complete formatting change. However, I think you guys are really, really going to love this. Consistent with the other forms in the Georgia Association of Realtors contract package, they have divided this form up into paragraph A and paragraph B. Paragraph A, in essence, is all the fill in the blanks. So key terms and conditions. This is the type of association, contact, assessments, special assessments, fees, everything it covers. All the fill in the blanks are now moved to paragraph A. And then paragraph B, consistent with the other GAR contract package, is further explanations to corresponding paragraphs. This describes and explains what is covered by the information in paragraph A. So, the type of association, what that means, the contact, the assessments, what that covers, what the buyer shall pay, what the seller shall pay, what's under consideration, liability for undisclosed special assessments, who pays for what, transfer, initiation, administrative fees, what they are, what they cover, who pays for what. All of that is filled in paragraph B, and they've added signature lines as opposed to just initial lines. So let's go back up to A. So that's the good news, and that's the major change. The thing that did not get changed is basically for the content of this form, the concepts, everything that is disclosed and required, that has not changed. This form has undergone major changes to that throughout the past couple of years. But content-wise, this is all the same. The seller is required to fill out all this information and the fees and what's covered and assessments and contact information for a buyer, so that a buyer may make an informed consented decision regarding whether to pursue a property with this community association. If the seller does not disclose accurate fees or any fees, then at closing, the seller will be responsible to pay those fees not disclosed, even if it is for the buyer's benefit. The reason it's not designed, the intent is not to punish the seller at all. The intent is that a lot of these management companies will only speak to the owner, the current owner of the property. And on top of that, a lot of times the current owner of the property has to pay to get that information. But regardless, a buyer, sometimes as much as they would like to, or as much as the agents would like to help perform ministerial acts by providing the contact information, these companies might not disclose the required information to a buyer. So there is, the seller is incentivized to get that information to disclose, or disincentivized that if they don't get it, they will have to pay for that. So that's the general gist of this form. In mid-year of last year, they did add, under the directions for filling out this community association disclosure, it's directions for the seller how to fill it out. And mid-year last year, they did add the sentence, seller should ensure disclosures being made are accurate by confirming the same with the community association and or association manager. And then for 2022, they added, and again, you guys, this should look familiar. This is consistent with the seller's property disclosure form. They added this whole paragraph about buyer's use of disclosure. While this disclosure is intended to give the buyers basic information about the community in which the buyer is purchasing, buyers should read the covenants and other legal documents for the community to fully understand the buyer's rights and obligations therein. This disclosure does not address all issues that may affect a buyer as the owner of a residence in this community. Assessments in community associations tend to increase over time. The covenants can normally be amended to reflect the changing preferences in the community. And again, just a note, the covenants are legal documents that are recorded, and buyers can find those online because they are public documents that have been recorded. All right. Just for comparison's sake, this is what the Community Association disclosure exhibit looked like in 2021. You see, it's just fill in the blanks. The paragraphs were just designed differently, and it's fill in the blanks throughout the entire form. And it got just a little bit difficult for people to read and understand who was responsible for paying what. And because it does involve a lot of money issues and restrictions, so forth and so on, they did change that from initials to actual, making you all dizzy, sorry about that, to actual signatures. So I think that is a step in the right direction for a change on that form. Like it, and it's consistent. All right, moving along to the brokerage agreements. We're going to start with the listing agreement. So this underwent major changes in 2021. We've got an hour. All right, major changes in 2021 where they changed some dates and so forth and so on. That got further changed mid-year 2021. So let's cover this. So this is, first thing they did was they changed it, instead of it saying exclusive listing agreement, they changed it to read exclusive seller brokerage engagement agreement. Why did they do that? Well, in Georgia, in order for a public seller to be a client, to engage in a client relationship with a broker, the client relationship in Georgia for real estate is contractually driven. A seller must sign the seller brokerage agreement to create the client relationship with the broker, and a buyer must sign a buyer's brokerage agreement to create a client relationship between the public buyer and the broker. So if for a seller, there's a couple of things going on. There is the creation of the client relationship, and then there is the marketing of a property to sell. Well, those two can commence at different times. For example, you might want to create a client relationship now so that you can fulfill your fiduciary responsibility and advise and guide and direct a seller what they need to do to put the house or the property in the best condition in order to take advantage of the market and get the most money from a buyer given market conditions. Well, until you are working with that public seller as a client, you really cannot advise them and guide them. But they might have to do things in order to get the house ready to sell to take advantage. So GAR last year recognized that, and they divided the time frame that the client relationship starts. They separated that out from the marketing time frame. So under paragraph 2, and in April of last year, conceptually they did this in January of last year, but it still got very confusing. It was all under one paragraph. So in April of last year, they separated this out and added a little bit more information. So under paragraph 2, you have the list price, and then you have the commencement date of the agreement. Again, this is the date that initiates or begins the client relationship between the public seller and your broker. And then you have an end date. Then the marketing, This is the date down here, paragraph 3B, the marketing commencement date. This is the date when the property is first marketed to the public. Now, lots of issues with the MLS services. So in April of last year, GAR added this paragraph, subparagraph A, all in caps. This is delivery of agreement to and listing with MLS. This agreement must be timely delivered to and listed with the above referenced MLS services in accordance with the rules of such multiple listing services. This obligation shall control over any conflicting or inconsistent language contained herein. So here's the deal. With FMLS and Georgia MLS, I cannot speak to any other MLS services because I am not familiar with their rules and regulations. But FMLS, their membership agreement. So if your broker belongs to FMLS, they must adhere to the FMLS membership agreement. FMLS states that once an exclusive seller brokerage engagement agreement is signed, it then becomes the quote unquote property of FMLS and is required within 2 days to be listed in FMLS, period. Now, if the seller doesn't want to start the marketing of that, the marketing commencement date for MLS purposes has to do with the status that that property shows in FMLS. But within 2 days of signing this, this listing must go in FMLS. Now, if the marketing commencement date is a date later than the commencement date of the brokerage agreement, then the status is that of coming soon. It can only stay in a coming soon status for 21 days. After and you can make it shorter than that, but that's the longest. After 21 days, it will automatically change to active. If the marketing commencement date and the coincides and is the same date as the start of the date that this listing agreement is signed, in other words, the start of the client relationship date, then it goes into FMLS as an active listing. So what happens if a seller signs a listing agreement? Because you guys, you want to get these signed. You want this business from the seller when they're ready to sign and create a client relationship with you. And there might be things that you need to do to help them, advise them, guide them, what they need to do to get the property on the market for maximum exposure. If it's going to be longer than the 21 days, I don't know about the other listing services, but FMLS has a new status called a registered listing. That's going to be if it is going to go, if you sign it now, but it's going to be longer than 21 days before you're going to market it. A registered listing can only be seen by FMLS, you as the agent, and your broker. It cannot be seen by any of the other members of FMLS. A coming soon status can be seen by you, the agent, your broker, FMLS, and all the other members of FMLS. Now, when I say seen, I just mean the information on the listing service. As property that's in a coming soon status may not be shown to the public. You cannot show it to your own buyers. You cannot show it to your office's buyers. You cannot show it to any other buyer if they're represented by an agent or not. Coming soon, it is not ready for public view at all by anybody. It can only be only the information on the computer and photos on the computer in FMLS is what's available. If you are going to show it to a public buyer or another agent, it must change to an active status. So again, the marketing commencement date has to do with the status that the property is in FMLS, and it must be changed to active within 1 day of the marketing commencement date, and it must go into FMLS within 2 days of when this is signed. If you are a member of both Georgia MLS and FMLS, any and all listings in FMLS must also be listed in Georgia MLS. Now, the only caveat is The property must be residential property. So commercial and I don't believe land is required to be in there. It must be in a FMLS compulsory area, and your broker must be a member of FMLS. New construction has to go in there from the phase of the drywall phase on up. So just wanted to talk about that. All right. Then under the additional page, I just added the reference, the form number to additional page. Now, under this agency section in dual agency, it got a little confusing because there's been this, dual agency is legal if it is disclosed and there is written consent. Now, a lot of brokers won't allow it, but that is a brokerage policy. That's not a license law issue. So what they changed in the listing agreement this year is it says what types of agency relationships are not offered by the broker. And then it always had this paragraph about the consent for dual agency, but a lot of agents, brokers don't allow dual agency. So it was weird. So they've just added the preliminary phrase, if the broker offers dual agency as one of its agency relationships above, then the seller does or does not consent. So that's just a little bit of clarification on that. Consistent with their universal changes, they just added the word further explanations to paragraph B. And then again, consistent with what we were just talking about the property entered into a multiple listing service. Again, in April of last year, they have added the sentence that internal marketing that only goes to other licensees within the seller's broker's firm is not considered public-facing marketing unless it is distributed to licensees outside of the broker's firm. Again, that's not for actually seeing the property physically. It's just for distributing information about the property. And they have added under commission this separate paragraph 4C, separate commission on a lease, that basically the seller is signing. This is a listing agreement to sell the property, but it does say if the seller actually ends up leasing the property or enters into a lease purchase or lease option, that the seller shall also pay the broker a separate leasing commission in the amount that was indicated in paragraph A, and notwithstanding any provision of the contrary, the payment of a leasing commission, including on a lease purchase or lease option, shall not relieve the seller from paying the commission at closing when it actually sells. Under the protected period, they had a whole, is it legal? Many listing agents are sending emails stating coming soon. Yes, if they have a signed listing agreement, they can state that the property is coming soon. So can the listing agent put in a registered listing, or do you have to have coming soon if it's under 21 days? If it's under 21 days, it has to be coming soon. The quote unquote registered listing is just for a time frame over the 21 days. Yeah, you get bombarded with phone calls. I know. Anyway, back to the protected period. They did have information that said a buyer as defined here, seller as defined there. They've taken that out from this paragraph and moved those definitions. They've added a new paragraph about definition of buyer and seller. But before I continue, let me show you here. Let me see if it's under here. Under the next one, under the buyers. Okay, I'll come back to here in a second. All right, so they've moved those definitions to the definition paragraph. And here's where they added this. I referenced this when I was talking about the lead-based paint disclosure. This is the listing agreement. Under the seller's property disclosure statement in April of last year, they added that the seller must provide the broker a current fully executed lead-based paint disclosure exhibit at the time as the signing of this agreement. This is to protect you guys and to protect them financially from an EPA fine. So they added that April of last year. Here is where they added definition of buyer and seller. It was under the protection period paragraph. They just added it here for the purposes of this section. The term seller shall include seller, all members of immediate family, legal entity, any member of a seller's family which owns, controls directly more than 10% of the shares or interest. That's if it's, for example, an LLC or some type of corporation. And any third party who is acting under the direction or control of the above parties. For the purposes of this agreement, buyer shall include buyer, all members of the immediate family, the same definitions if it's an LLC, so forth and so on. Then under the referral section back in April of last year, they added the reference to a referral to a builder. So it says seller hereby authorizes broker to refer seller to another real estate licensee or broker for brokerage or relocation services, or to a builder for services not related to the sale of the property. And then under brokers' duties to seller, back in April of last year, they reworded this paragraph a little bit, just to make it, these contracts, well, all of the GAR contracts, the brokerage agreements, the purchase and sale agreements, they are all designed to protect you, the agent and your broker. So under the broker's duties to the seller, this paragraph has just been reworked a little bit back in April. And it does say the broker shall promote the interests of the seller by, 1, seeking a sale price at the price and terms stated in this agreement or at a price and terms acceptable to the seller. Provided, however, the broker shall not be obligated to seek additional offers to purchase the property while the property is subject to a contract to sell, unless the brokerage agreement for engagement so provides. 2, timely presenting all offers to and from the seller, even when the property is subject to a contract to sell. 3, disclosing to the seller material facts which the broker has actual knowledge concerning the transaction. 4, advising the seller to obtain expert advice as to material matters which are beyond the expertise of the broker. And 5, timely accounting for all money and property received in which the seller has or may have an interest. So that paragraph has just been reworked a little bit. And they added the reference to the form number for additional pages attached. And that's about it for the listing agreement. All right, there is a question. Does Georgia MLS have a registered listing status? I do not believe so. If so, then when 21 days? I would have to find that information out from Georgia MLS. It does, I don't know. I can't answer that without looking more specifically at Georgia MLS. All right, buyer brokerage agreement. A lot of changes to this, a lot of new formatting and some changes to this. So this is the 2022 version. There have been a lot of changes to this based on a lawsuit, and I'll cover that in a second. So under the agency and brokerage, it again, consistent with the listing agreement or the seller's brokerage agreement, it's going to take me a while to get used to that. It does say if the broker offers dual agency, they just added that if, then the buyer does or does not consent. Now, this commission paragraph is completely new formatting and new verbiage. And you'll notice too, they added the protected period here because what's protected? Well, what's protected is commission. So it makes sense for that to be under the commission paragraph. So let me show you guys what it used to look like. Well, let me get to, well, I'll wait till I get to paragraph B on that. All right. So basically, it states, this is completely different. It used to state that the in Georgia, it usually the buyer's broker gets paid from the listing broker, And the buyer's broker, however, is entitled to X% of a commission, excuse me, in the amount of either X% of the sale price or flat fee or other. Then there was a paragraph that said, if the seller or the seller's broker does not pay that to the buyer's broker, the buyer agrees to pay to make up the difference. And you had the option of negotiating the buyer shall make up that difference or shall not make up that difference. GAR changed it in 2022. Instead of it being a buyer choice to pay the commission, it is now a buyer obligation to pay a commission. And so what it says, let me just read it. Buyer's commission obligations in purchasing real property. The buyer agrees to pay the broker the commission set forth below at the closing of a contract to purchase, as that term is used herein defined, entered into during the term of this agreement, minus any commission paid to the broker by either the seller's broker or the seller. Buyer acknowledges that the commission, if any, being offered by the seller's broker is usually set forth in the multiple listing service in which the property may be listed. So a couple of things they've done here. You see my notes in red. It is now a buyer obligation to pay a commission versus a buyer choice to pay commission. They reference the seller side paid commission is listed in an MLS service. Also, you'll see in subparagraph C, there is now reference commission on a lease. And as I mentioned at the beginning, protection period is now here because it has to do with commission. So it has the commission is a % of the sale price, a flat fee or other, and separate commission on a lease. If buyer leases property or enters into a lease purchase contract or lease with an option, buyer shall also pay the broker a separate leasing commission of X amount of dollars, so forth and so on. And then the protection period time frame is here. I'll get into that a little bit more in the further explanation. So then it has further explanations. They've added that verbiage consistently. So here under paragraph B, under the commission, again, this entire thing is now reformatted and new verbiage to correspond to A4. So here is what it used to look like. Let me make this a little bit bigger for you guys. This is what it used to look like in 2021. It had information about broker's entitlement to commission. Then it had seller normally pays commission. In the event seller does not, the difference will be paid by the buyer. And again, you had the option of choosing shall or shall not pay that. It had information about commission on a FSBO. It was a whole separate paragraph about commission on a lease, and the protection period was all spelled out there. So now in 2022, this is all reformatted to correspond to how it now looks in the new verbiage in paragraph A4 under commission. It's now, again, a buyer's obligation to pay the commission, and it's they agree to pay that minus however much a seller is selling. They removed the term seller normally pays commission. They still have the information about a for sale by owner, commission on lease, and the protection period. It's just the verbiage corresponds to those fill in the blanks. None of the rest of this has changed. And before I get into these two new paragraphs, let me go back here, and I referenced a lawsuit. So let me talk a little bit about, do I have it here? I have it somewhere, but let me see if I have it here or where I have it. There we go. All right. There is a lawsuit that started in 2020. It actually was initiated in 2019. It is the National Association of Realtors versus the Department of Justice antitrust lawsuit. And basically, GAR has made these changes in the buyer brokerage agreement to be proactive regarding buyer paid commission based on what's been going on with this lawsuit. In November of 2020, the Department of Justice sued NAR, National Association of Realtors, for their MLS policies regarding disclosure of commission. The allegation is that the buyer is really, you guys, the only party in a transaction who has no idea how much the brokers are getting paid. The seller knows it because the seller initiates the commission. All the brokers know it because it's in an MLS service. The buyer is potentially the only one who has no idea how much brokers are getting paid. So it's a potential antitrust issue because number one, the buyers are marketing their service. Buyers agents are marketing their services, quote unquote, for free to a buyer, but it's not. They're still getting paid. The buyer, this argument is a circular argument, but in essence, the buyer's paying for it because the seller accounts for that in what they're charging and the fees, so forth and so on. But the bigger issue is agents may select properties to show based on the commission they're going to get rather than a property that might be in the best interest of the buyer. Brokers are limiting access to lockbox to members of NAR affiliated with an MLS. You guys, I found out in this GAR class that I took that through, I've never heard about it here in Metro Atlanta where I'm a broker, but I apparently in other parts of Georgia, there are apparently agents representing sellers, and an agent with a motivated, qualified, ready, willing, and able buyer wants to see their property, but that agent did not belong to that MLS service. And the listing agent wouldn't let them see the property because they didn't belong to that MLS service. So that was a bit interesting. So that was in the lawsuit too, about brokers limiting access to lockbox to members of NAR affiliated with only if you were in the same MLS would they let you see the property. Then what happened was that lawsuit was actually settled out of court. NAR and DOJ settled out of court. NAR agreed to change their policies and disclose to buyers the offer of commission that the seller's broker offers the buyer's broker. However, in the bizarro world we are living in right now, in July of last year, the Department of Justice completely abandoned the settlement agreement. And they said, no, we signed a settlement agreement out of court. We agreed to it, but no, we're going back on that. We're going to modify the terms and allow us, the DOJ wanted to expand their investigation. That is completely unheard of one of the parties abandoning a settlement agreement. So then in September of last year, NAR filed a countersuit against the Department of Justice for its unprecedented action of withdrawing from a legal settlement. As of October of this year, 2021, the Department of Justice will apparently continue to expand their investigation. So it is back still in the courts, not settled. There is a link there. You can just Google NAR versus DOJ and see the latest. I do have a link for you there, but it is just the wildest, wild west. It's just the wildest thing. But anyway, GAR is being proactive and changing the way the commission statement reads in the buyer's brokerage agreement in anticipation of what's going on. So does this mean that agents will start not putting percentages in FMLS? No, it's exactly opposite. You have to disclose what everybody is getting, is getting. You have to disclose what potential fee for service is. Yeah, DOJ is bored looking for something to do. Yeah, they've got a lot on their plate right now. All right, moving along, 2 new paragraphs in the buyer brokerage agreement. And one is, again, this is a reflection of this extremely fast or seller's market that we have been in. And it says buyer buying property sight unseen. The broker hereby advises buyer that there are significant risks in buying a property sight unseen, since pictures, videos, and other information about the property may not accurately reflect the true nature and condition of the property or area in which the property is located. Therefore, if the buyer purchases the property sight unseen, the buyer agrees to indemnify and hold the broker. And again, further in these contracts, it does define broker as extending to you, the affiliated licensee, but agrees to indemnify and hold the broker harmless from any and all claims, suits, and damages arising out of or relating to any issue that the buyer and buyer's representatives, other than the buyer's broker, would have reasonably observed had the buyer visited the property and surrounding area. I strongly suggest, as a point of practice, that you have your buyers sign disclosures regarding the potentialities of buying a property sight unseen, buying a property without an appraisal contingency, buying a property without a due diligence time frame, buying a property without inspections. If you have taken other of our contracts classes, we do share, we have an attorney written disclosure form that you can brand to yourself regarding that, but please run that by your own broker. If you email me, I will be more than happy to share that document with you that you can brand yourself. It is written by an attorney, and basically it is disclosures to buyers in this crazy market of potentialities in the future of what might happen if they do choose to go binding on a property and forego some of those issues. Okay, further, for 2022, GAR has added definition of buyer and seller. Again, this is the same as in the seller's brokerage agreement. This information was contained under the protection paragraph. They've moved it where it's more appropriate under the definitions paragraph. And under the referrals section in April of last year, they added consent to refer to a builder. And under buyer default, they have added this year, for January of 2022, they have added that the buyer agrees to immediately pay broker its commission or unpaid portion thereof, again, to correspond to the new paragraph A under commission. And then in April of last year, they added this verbiage to the subparagraph. Buyer, okay, so basically buyer default. Notwithstanding any provision to the contrary, buyer agrees to immediately pay broker its commission or unpaid portion thereof in the event that any of the following occur. B, buyer agrees with the seller to mutually terminate a contract to purchase under which the broker would have been paid its commission and the transaction had closed. That had already been in there. What they changed in April of last year is without the prior consent of the broker, except if such mutual termination is entered into during a due diligence or other period during which the buyer may terminate without penalty for any or no reason. In other words, if the buyer terminated within prior to the expiration of a contingency time frame, that's not the deal. But if they terminate outside, then the broker is entitled to commission, because the buyer would then be in default. And then the part about the buyer unilaterally terminating, that has been in there. But for January of 2022, they have added this new sub paragraph D under buyer default. Buyer enters into a contract to purchase real property during the term of this agreement and then later closes on the same, even if the closing is after the expiration of this agreement where the broker has not paid its entire commission. All right, and then again, they just reference the form number for additional pages, and that's it for the buyer brokerage. All right. Seems like commission would be hard to collect. It gives the grounds for a lawsuit for your broker to legally pursue it from the buyer as a breach or default on the buyer brokerage agreement. All right, temporary occupancy agreement. This just got a couple of things got added for clarification purposes. It basically, it used to have, the verbiage got changed to be a little bit more clear. It used to have more of the quote unquote old fashioned legalese with more of the whereases and hereby and so forth and so on. So they've just changed it just slightly. Where it says the seller shall have the right to continue to occupy the property for X number of days from the closing date. So they just added right to continue to occupy. Then paragraph 8 is a brand new paragraph. It states, the seller shall be liable for the expense of repairing any damage to the property caused by the seller or seller's family members, licensees, and invitees, excluding normal wear and tear. The buyer, however, as the new owner, shall be responsible for making repairs to the property. Because let's say you're under a temporary occupancy agreement, and let's say that there's some sort of substantial damage to the property, some weather damage, or I don't know, something along those lines. Then the buyer, who is the new owner, is the one that has the homeowner's insurance on the property. So they are going to be responsible for any kind of those repairs. But the seller, who is occupying the property right now, is the one who is responsible for any damage that they cause by occupying the property. And then this paragraph 10, they have added, basically this is, if the seller does not vacate when they say they're going to vacate, they are now deemed a tenant at sufferance. That's been in there. But what they've added is they say that seller shall be evicted and shall pay the buyer, quote unquote, holdover rent during that period. They had to add the term holdover rent. So this agreement does not make the tenant, the seller who's occupying the property, it does not make them a tenant. You do not want them to be a tenant because, number one, all of the Georgia landlord tenant laws kick in, including terms of notice to have to, before you can evict them, you have to give them 60 days notice if they're a true tenant, so forth and so on. So they're considered a tenant at sufferance, and what they agree to pay is holdover rent, because you still, now the new buyer who now owns the property is still going to have to go to court to evict them, but you won't have to give them a 60-day notice, and but you are still going to have to evict them. Anyway, those are changes to that form. Request for confirmation of presentation of offer. Again, this was a brand new form in January of 2021. And basically, this is only signed by the agents. This is if a buyer's agent feels that the seller's agent did not present their offer. This is the seller's agent saying, yep, I presented the offer. So a couple of the things that they've changed for 2022, they've added, it used to have just that the broker signed it. Now they've added that you as the affiliated licensee can also sign this. And they have added reference, NAR added a new standard of practice 1-8 this year. So this form now references that new NAR Code of Ethics, Article 1, Standard of Practice 1.8. And it says, upon the written request of the listing broker who submits a counter offer to the buyer or tenant's broker, the buyer's tenant's broker shall provide as soon as practical a written affirmation to the listing broker stating that the counter offer has been submitted to the buyer's tenants, or a written notification that the buyer's tenants have waived the obligation to have the counter offer presented. So it used to just be in terms of a buyer's agent requesting from a seller's agent, and now it's the reverse, a seller's agent requesting that same confirmation from a buyer's agent if it went through the counter offer process. So that is a new, just a new reference to the new standard of practice. Again, you guys, there is a form that the public signs regarding rejection of offer, but we can't mandate a public person sign something. But if you are a realtor, then you are beholden to the Realtor Code of Ethics. And if you are a licensee in the state of Georgia, you are beholden to license law. So the specific license law is mentioned in the two articles, standards of practice under the Articles of the Code of Ethics. All right, option agreement. I'm going to briefly go over this because I do not see this used a whole lot. but the option agreement has been completely revamped and updated. Do not get confused. This is not the option for due diligence that I addressed earlier. Let me go back here and make sure you guys don't have any questions. Okay, I can see in commercial, residential, commercial all the time. Okay, have return. Okay, you guys are having a discussion about that. Who defines damage? It is not very clear. Very good question. You buyers agents, when you're doing a walk, if there is temporary occupancy for a seller, point of practice might be to go through what hopefully you're doing a final walkthrough anyway, but you might want to make any notes of the status of the property. There is a guide on the lease move in, move out form if you want to use that, or take photos or something like that, because you would want to probably find some way to substantiate or prove what damage was pre-existing and what damage was caused by a seller who does have temporary occupancy of a property. You guys are asking some absolutely phenomenal questions, but a lot of these are legal questions, and I am not an attorney. I am not a judge. I am a broker. I will just say that for point of practice, as a broker, I suggest you document with photos, with signatures, with all kinds of things as much as possible to protect yourself, your license, and your clients. All right, moving along. Again, this option agreement, this is a completely separate issue from additional option money for a buyer's due diligence period. This is a separate option agreement for for other options. It's money paid, good and valuable consideration, paid to the seller, set forth receipt and sufficiency of which it does have to do to purchase a property, but it is a completely separate option agreement. Again, I don't see this used a lot, so I'm not going to spend a lot of time on this other than to just say that, again, the option money is not trust money. It is not earnest money. It is money paid directly from the buyer to the seller. It is not held in trust. It is not held in escrow. It is not held by a third party. And then there is the option that the option money is or is not credited towards the purchase of the property. And it does have the payment, if any, shall be in addition to any commission. The broker for services rendered in this connection. Basically, the seller, there's commission that you can earn on an option agreement. Seller agrees to pay a broker the fee, the sum of X amount of dollars. That is basically a commission on putting together the option, in addition to any commission the broker will earn if the party ends up actually closing on the property rather than just providing the option. Basically, an option is a buyer saying, look, seller, take the property off the market for me while I figure out if I am going to buy it or not. And I'm going to pay you something for you not agreeing to sell it to somebody else. That's in essence what an option is. And you as the agent or your broker can earn commission for putting that deal together. And then if an action closes, there's additional commission paid on a closing. And then it goes on to say, if the option is done and the seller is unable to fulfill the seller's obligations to sell the property to the buyer, then there is a refund. In other words, if the seller defaults for whatever reason, the buyer will get their option money back, even though it is otherwise stated it's non-refundable. All right. Whew, this one created a lot of conversation in 2021. Property sold with right to request repairs exhibit. This is used in place of a due diligence. It is not used with a due diligence. A buyer either buys a property with nothing, or with a due diligence period, or with the right to request repairs. They do not buy it with both the due diligence and the right to request repairs. They are completely different situations and circumstances under which the buyer may terminate. Under due diligence period, a buyer may terminate for any or no reason as long as they send notice of that termination prior to the expiration of that time frame. They don't even have to give a reason. They can just say, I'm terminating based on my due diligence period. The property sold with the right to request repairs, the only way a buyer can terminate is they have to have the property inspected by an independent home inspector. They have to submit an amendment to the seller request. Well, they don't have to if they don't want anything done, but if they do want the seller to address some issues, they have to send an amendment to the seller along with the list from the inspector saying, this is what I want you to repair. They negotiate through that stuff. If the seller does not agree to do that, the buyer may terminate within this negotiated time frame and get their earnest money back. If, however, the seller does agree to perform all of those repairs on that amendment, the buyer may not terminate. The buyer is now obligated to go through with the purchase of this property. This used to be in the purchase and sale agreement prior to a buyer having the right to due diligence. But a couple of key things for you guys. Number one, you don't do both. The buyer does not get a due diligence and a right to request repairs because the termination rights are completely separate. What they added in 2022 is they added this bottom sentence, thank you, GAR, that says, and the buyer shall be, basically, if they can't negotiate through the amendment to address those issues, and it's not just general issues, it's specific items that are defective, and that is defined further on in this exhibit down there under paragraph 5B under defects. But basically it says if they negotiate through that amendment and the seller does not agree, the buyer has the option of continuing on with the property, buying it as is, or the buyer may terminate and buyer shall be entitled to return a buyer's earnest money. That one phrase was missing last year, and thank you, GAR, for putting that in. That was always the intent, but that was missing. Then they also added, notwithstanding any provision to the contrary contained herein, if the seller agrees to repair all defects timely presented by the buyer to the seller, then the buyer may not use this exhibit as the basis to terminate this agreement. Again, it's not a due diligence. You can terminate for any or no reason. If the seller agrees, buyer is locked in. All right. So those are good changes, more clarification. Oh, all right. Assignment. We have a lot of agents working with investors, and basically what investors are doing is they will go put a contract on a house for sale, but they have no intention of actually living in that house. They want to then turn around and assign their rights in the contract to another buyer who's actually going to live in that property. So a couple of things. Number one, the GAR purchase and sale agreement is not assignable without the seller's written permission. Oops, I'll get back to that. And it says under, okay, let me just point it out in the, let me go back here. Under the purchase and sale agreement, I'm going to prove this to you guys because I get arguments about this all the time. And all you need to do is read the contract. The contract is nothing more than a set of instructions. And let me see where that is. I'm sorry, give me 1 second. I just want to show you guys where this is. Paragraph C4E. All right. So paragraph C4E. here we go. I don't have it underlined because it's not a change, but entire agreement. This is I'm back on the purchase and sale agreement. Very last sentence. This agreement may not be assigned by the buyer except with the written approval of the seller, which may be withheld for any reason or no reason. The assignee shall fulfill all the terms and conditions of this agreement. So you agents working with, you buyers agents working with investors, don't think that an investor, don't go under contract with a buyer thinking that that investor can assign it to somebody if the seller doesn't agree. And there is special stipulation. You buyers agents working with investors, you need to use this special stipulation, 611. Seller consents to assignment of purchase and sale agreement. The seller consents to buyer assigning this agreement to another buyer and having the assignee become the buyer thereunder. That's key. You've got to use that in order to not default your investor buyer on the contract. So I wanted to point that out. Now, under this assignment, now this is an agreement not between the buyer and the seller. This is an agreement between the assignor and the assignee. The assignor is the original buyer. That's the person who assigned the purchase and sale agreement with the seller. And usually that's an investor. The assignee is somebody who's actually going to live in the house or an actual end buyer. So the assignor, the original buyer, has no intention of living in the house. They have an intention of making money by selling their rights to a contract. So they find somebody who wants to live in the house and they assign their rights to the purchase and sale agreement to that assignee. So that's what all of this information is. It talks about the assignment, the assignment's rights, the assignment price. So the assignor, the investor, in essence, is under contract with the seller for X amount of dollars. That investor then sells their rights in the contract to the end buyer for the assignment price. So this is not the purchase and sale price. This is the price between the investor buyer and the end buyer. The seller still gets whatever the investor buyer went under contract with the seller. Now, in 2022, they've added a lot of verbiage to help understand this information, this document. So under warranty of parties, they've added this sentence that says assigner warrants that assigner, in other words, the investor who's the original buyer with the seller, warrants that I have the right to assign the contract. That's what I just talked about. The seller has to agree by agreeing to that special stipulation. Then under entire agreement, it states no representation, promise, or inducement not included in this agreement shall be binding upon any of the parties. In other words, any money that changes hands has to be written out and agreed upon on this document. Then commission. So what about you guys? Where do you get commission? It says in the event that a licensed real estate broker other than the seller's broker or the buyer's broker. So the seller typically has their own broker. You as a buyer's agent, let's say you're working with the investor, you would be the buyer's broker because that's with reference to the buyer in the purchase and sale agreement. If you find, or your investor finds another buyer who's going to actually live in the property or be the end buyer, and they don't have their own agent, then they don't have an agent, and you get paid on the commission regarding the purchase and sale agreement. But if that end buyer has their own broker, now we've got three brokers involved: a broker representing the seller, a broker representing buyer number one, who's typically the investor, and a broker representing buyer, in essence, number two, who's going to live in the property. So it says, in the event a licensed real estate broker other than the seller's broker or the buyer's broker is the procuring cause of the assignment of the purchase and sale agreement from the assignor/investor to the assignee and person living in the property, the following terms and conditions shall control what happens to the commission. In consideration of the payment by the assignee to the broker representing buyer number one on the contract, that's the assigner's broker, a licensed real estate broker and buyer's broker under the purchase and sale agreement, the amount of X amount of dollars, which is the assignment commission, is in full satisfaction of commission payable to the assignor's broker under the purchase and sale agreement. And okay, basically, bottom line, seller agrees to pay a commission to a broker working with a buyer. The buyer, number one, is the investor. If the investor buyer finds buyer number two, who's going to end up living in the house, then based on this document, the broker working with the investor gets paid this commission by as written out here. If there's a third broker representing the buyer who's going to live in the house, they'll end up getting the commission from the original purchase and sale agreement from the seller's broker. That's what all that says. And believe it or not, this is way more clear than it used to be. And then it talks about earnest money, so forth and so on. So again, regarding, I already pointed this out, regarding paragraph number 4 above, there's that reference to that special stipulation that we have covered. All right. Oops, I added that twice or else I'm going backwards. Okay. Closing attorney acting as holder of, can an agent be engaged in an assignment agreement with a seller? It just needs to be disclosed, and you need to have everything all squared away and who represents whom and who is getting paid what. And the actual seller, the listing broker cannot agree to an assignment. It has to be the actual seller. So I'm not sure, Heather, if I answered your question or not. Buying this assigned property contract. Just received an email. Yeah, you seller in the GAR and the RE forms, you need that permission. If you're binding under another contract, you'd have to read the contract regarding that permission. All right, closing attorney acting as holder of earnest money. You guys, this is an exhibit. The changes made in April of 2015 are what I'm talking about here. But this is an exhibit. The buyer and the seller initial this. This is saying we intend for a closing attorney to hold the earnest money. Here's who that closing attorney is going to be. This is what got changed in mid-year. The alternate holder. The buyer must immediately notify all the parties if the closing attorney fails to become the holder. The alternate holder, who must be a broker in this transaction, shall be, and you would either list the buyer's broker or the seller's broker. If that's left blank, then it says, in the event an alternate holder is not named, the alternate holder shall be the buyer's broker. So you guys, this is signed or initialed by the buyer and the seller. This is an exhibit to the purchase and sale agreement. Then the buyer has 3 business days after the buyer goes binding with the seller to get the closing attorney to agree to be the holder. So this is not part of the contract. The buyer and the seller do not sign this. This is only signed by the closing attorney, and it's the closing attorney agreeing to be the holder. And so you will see the only signature is that of the closing attorney. This is not an exhibit to the contract. It is a standalone document. And what they added in April of last year is a place for the buyer's broker and the seller's broker. All right, this is that brand new form for January of 2022. This is the new binding agreement date confirmation amendment. We've had a good discussion about this. This talks about what the binding agreement date is, and you fill that out here. It defines binding agreement date, and then it states in signing below, the parties acknowledge the above referenced binding agreement date is accurate, and that's, again, you reference it up here, is hereby incorporated into the above reference agreement and shall control over any conflicting binding agreement date previously referenced elsewhere, and that is signed by everybody. That's the new form. And then I'm not going to cover these in depth, but the estimated net to seller form has added HOA closing fees. And I believe they've added a couple of other things. The estimated cost to buyer form They have moved prepaid interest up to the financing cost. It used to be under escrows, but that didn't make sense because it's a prepaid cost. And they have added more about HOA fees, and they've added the Georgia intangibles tax. The lease, let me talk about this, and then we'll talk about the special stipulations really quickly. I promise I'll be done in 4 minutes. Under the lease, a couple of things that they have changed. They added this whole paragraph 13 about early termination by the landlord. The landlord shall or shall not. It's been in there, but it's been further explained and more options in there about early termination by the landlord. And that's in paragraph A in the fill in the blanks. And then they've added the same thing about notice, that even if it's by email, even if it's not opened by the recipient. They've added corresponding additional language about the early termination by the landlord that says if the landlord does have the right to early terminate the lease. And again, that's by checkbox option in paragraph A. Then they've added this, you guys, you agents working with landlords on rental property. They have added under the paragraph about denial of access or right of access and signage. They have added this this information here. For each occasion where the access rights described above are denied. Basically, this is a landlord who has a tenant in there and they're going to put the house up for sale, or they need to go in there and access the property. For each occasion where the access rights described above are denied, the tenant shall pay the landlord the denial of access fee as liquidated damages in the amount set forth elsewhere herein. They've also added that visitors may take photos and capture video of the premises to help them remember the specifics of the property. Again, that's if a landlord is changing it from a rental property and they're selling it. And I believe that is all the substantive changes in the lease. So let me go back to let me cover the special stipulations and we will be done. All right. All right. The 3 new special stipulations for 2022 is, again, the one we talked about. If you're selling land and the land qualifies for preferential tax treatment, you listing agents, you will want to use this to protect your seller from having to pay back taxes for potentially 10 years. Special stipulation 317, repairs made by seller during the transaction. The seller will obtain any required permits and or certificates for the completion of the repairs or construction as is made part of this agreement and provide the buyer with applicable documentation. That would be a special stipulation that would be appropriate on an amendment to address concerns with the property, or the amendment to address repairs if you go binding with the right to request repairs. And then this brand new one that we talked about, seller consents to the assignment of the purchase and sale agreement. And then I also have in your handout, these were some situations and special stipulations that GAR came out with in November of 2021. They are available in the winter edition of the Georgia Realtor magazine, but in your handout, you have these, and I've got a couple of pages of these regarding all time deadlines shall expire at a specific time. And here is information about notices being sent via text. As a broker, I encourage you to not do that. Do not send notices by text. Here is one about the cleanliness of the house at closing, a special stipulation that the buyer warrants they don't have other nearby property under contract. Here is information about getting covenants and special stipulation about paying. Here's the appraisal gap special stipulation. Here is the buyer right to terminate this agreement if the amendment to address concerns is not signed condition of systems and appliances. All of those were in November of 2021. And again, before you leave, please type in your name, license number, email address. Please confirm all contract questions with your broker, all legal questions to the GAR helpline or an attorney. There is our link where you can get additional classes. The course is offered through the Georgia Real Estate Academy. It is hosted by Maximum One Realty and Maximum One Realtor companies. as well as there are a lot of others that are hosting our classes. CE credits recorded within 3 to 7 business days. You can contact Heidi if you have any questions about that. And again, I have a YouTube channel called Real Estate Made Crystal Clear, where I go in depth on a lot of the GAR contracts. My YouTube channel is designed for real estate agents throughout all of Georgia, regardless of your brokerage affiliation. And whew, we made it, everybody. Yay. So what do you think? What do you think? Type in your, I'm interested in your comments. Not a lot, actually more than it seems like there is, but not a lot to the purchase and sale, but a lot that protects you and more clarify and things like that. So again, thank you guys so much. I will stay on, and I'm gonna stay on and answer whatever questions anyone may have. You guys, please have a happy, healthy, joyous, prosperous new year. Continue to be a blessing to everyone, the public, as well as your colleagues, your co-op agents, your brokers, and all of their staff with the real estate license that you have earned and you keep. And again, I appreciate your time and attention. And our CE classes are open to any and all agents. We have a huge philosophy in training and different. So question, is the buyer responsible for paying the difference in commission? Yes, now it is an obligation to pay the difference rather than a choice to pay the difference. That verbiage was changed on the buyer brokerage agreement. It used to be shall or shall not pay the difference. So again, that might be a discussion that you're going to want to have with your broker in your own firm regarding how the broker wants to address that, but that has been a change. Thank you so much. I enjoy teaching so much. Yes, Merry Christmas, Angie. Post location of the materials again. All right. You can go to, and let me get rid of the rest of this information. There we go. All right, handouts are available. If you go to eagentweb.com and select training videos, I would email them to you, but it's so many different documents. It's too big of a file to email. I can't figure out, I tried to combine them into one PDF and I can't figure out, it did that. And then it said portfolio. When I tried to access it, it was prompting me to buy an Adobe product. So the easiest way for me to do it was to post it on that website. It's not a password protected website. It's out there for you guys, where you guys can download all of the materials that I went over today in class. And I have recorded it, so we will post the video. Any other questions? Yes, lots of information. When agent state offers will be collected by XYZ date, time, submit them. This would be a good time to use the confirmation your offer was presented. Yes, I would use that. Again, that is just a confirmation by the other agent that you did present the offer. There is a form, you listing agents, there is a form called rejection, notice of rejection of offer. Your seller is not required, you can't require a public person to sign anything. But you guys all are beholden to license law, and if you're a realtor, to NAR code of ethics. So there are things you have to do, but you would probably be best served if your seller does sign that notice of rejection for any offers they are not rejecting and send that back to the agent representing that buyer, just to prove that you did present it and it really is the seller choosing another offer. Because there's a lot of buyers that think, my offer was amazing, I can't believe the seller didn't choose my offer. But there's a lot more to a seller choosing an offer above and beyond just the price. There's all the terms. There's what contingencies are in there, other option fees, what occupancy. There's all kinds of other terms that a seller evaluates when trying to make a decision to go under contract with one buyer versus another buyer. Once the transaction closes, a temporary occupancy agreement is in place and the seller has passed the move out. Is there still an agent or broker to get back involved or turn it over to an attorney? turn it over to an attorney. That becomes the buyer, who's the new owner of the property, has to go to magistrate court and file an eviction of that tenant at sufferance, even though there's not a lease. So I would refer them to an attorney so that they can go through that process to actually have that tenant at sufferance removed from that property. I will tell you guys, with a temporary occupancy agreement or even with the possession issues, I'm not an attorney and I'm not a police officer, but you cannot, if somebody leaves possessions in a property, the new owner cannot necessarily just go in there and put all the possessions on the curb or sell all the possessions or take them to the dump. That could potentially be considered theft by conversion, which is a criminal act. So if you are working with a buyer who owns a property and at time of possession, they go into the property and either the person is still there or there are possessions there, your buyer needs to consult an attorney regarding what to do with those possessions, because again, they are not the buyer who now owns the property. Those possessions do not automatically become their possessions because they've been left in the house. It could be considered a felony for them to do anything with that. So they need to consult an attorney regarding what to do with that. They may have to go through the eviction process to get rid of the seller's possessions from that property. These are all questions that are legal questions above and beyond our scope as real estate agents and real estate brokers. I'm just bringing this to your attention in case your public people ask you about this. You need to refer them to an attorney for legal advice on what to do regarding those situations. We did have those situations, and so some of these terms I'm throwing out at you are things that have come up. Submission time is not the time the seller must reject or approve, but the buyer is free to move on. Yes, for the time limit of an offer means an offer is open for acceptance without change prior to that time. If a seller is going to make a counter offer to a buyer, the time limit is of no consequence because the seller's not accepting, or in the case of a counter offer backwards, the seller's not accepting those terms. So the time limit is a moot point. It has nothing to do with anything. It was rejected. There's a whole new offer initiated by a seller back to a buyer that we call a counter offer. That may or may not have its own time limit. So the time limit is not a time frame within which the other party is to respond. It strictly is these terms with no change are open for acceptance until that time. Once that time's gone, they're off the table. You cannot have a contract if the parties accept those terms after the time limit. It's not a contract, it's a counter offer. And if the seller is going to change the terms after the time limit, it's a counter offer. So I had 20 offers on one listing, used a rejection form signed by the seller, approved. Good, definitely a good idea. The other thing is just signed by the agents, and some agents unfortunately do not trust other agents. Do you think there will be a shift in how or who pays commissions? I think we're already seeing that shift, Holly. Well, I'm not even gonna say generally speaking, because there's no, especially with the antitrust issues going on. Each public person contracts with the broker regarding how the brokers and how you guys as agents get paid for the valuable services you perform. A lot of times that listing broker will share that commission that the seller pays the listing broker with a buyer's broker. That is communicated in an MLS service because we are a co-op state. We do things by co-op. We're not sub-agents, at least here in Metro Atlanta. So you can reasonably expect to be paid what is listed on that MLS listing as a co-op commission. You listing agents, y'all got to check that stuff. You cannot put one commission on there and then come back and say, oops, it was a mistake, and do the bait and switch. You might lose that case and be obligated to pay what is in that MLS co-op fee, even if it's a mistake. You as the listing agent, you have a responsibility to check how that property, that seller's property appears in an MLS service, not only to the public, but to every other agent out there that's a member of the MLS service. You have that responsibility to do that, whether you're inputting the listing into the MLS or you have a staff person that's your broker doing it. That is your responsibility, and you may be obligated to pay even if it is a mistake. But we are seeing a lot of issues where a seller's broker, a listing broker, a seller is saying, no, I'm just paying my agent. I'm just paying my broker for their services. I'm not paying an agent representing a buyer. I don't agree that my broker can share that commission with a broker paying a buyer. Let the buyer pay for their own services. So due to the fast nature of this market and the fact that there are fewer listings than there are demand, supply is lower than demand, we are starting to see that in a lot of properties for sale right now. And so you buyer's agents, couple things for you buyer's agents. Number one, you need to have the discussion with your buyers about commission. Number two, you need to secure in writing your commission that your broker is going to earn by working with the buyer. There is a form, it has not been changed. There is a form. I don't know why buyer's agents don't get those commission instructions filled out at the same time you're negotiating an offer. A lot of you guys work pro bono and get upset about it. There is a form in GAR called confirmation of co-op commission agreement to be used prior to showing. That is a form. Absolutely, I would use it if the property is not in MLS, but you might want to use that and get that signed before you ever show a property so that it does not come up an issue later if there's a mistake or whatever in the MLS listing, to ensure that you guys get paid. We've got an issue right now where listing broker put $1 as the co-op commission in the MLS. Buyer's agent, they got everything under contract, everything's negotiated. About a week or so before closing, the buyer's agent fills out commission instructions to the closing attorney, sends it to the listing agent. It had 1%. The seller's agent went and signed it, said, no, it's only $1. And the buyer's agent said, well, I never would have done it for $1, which that's a license law issue too. You can't select properties by the commission you're going to earn. And the listing agent said, I disclosed it was $1. That was clearly stated. Variable rate commission was marked yes, and it was clearly stated the buyer's broker is going to get $1. Well, guess what? It went to closing, and guess what? Guess what the buyer's broker did? And the buyer's broker put $0 for the buyer to pay for commission. So guess what the buyer's broker got? $1. Yeah, $1. Wasn't addressed up front. The buyer's broker mistakenly assumed or read it as a percentage as opposed to $1, but it was fully disclosed by the seller's broker. And absent, they're both members of the both brokers are members of that MLS service, and absent anything else in writing, it was clearly disclosed what they were going to get. The buyers, anyway, so I mean, there are still a lot of listing brokers that are sharing that commission. If you go finding under the GAR seller's brokerage agreement, there is a place the seller does have to agree what happens with the money that they are giving to a listing broker. If the listing broker is going to share it and share what amount under what circumstances, that got changed in 2021. There was no change for 2022, so I didn't address it in this class, but that is all delineated, and the seller must agree what happens to their money, how it gets shared, and any changes to that sharing in the listing agreement. But that's under the GAR forms. If a seller signs a different listing agreement, then in essence, the seller agrees to pay the listing broker X amount of dollars, and there's no information or disclosure or a signed agreement regarding what that listing broker has to do with that money that they earn by selling that seller's property. Now, a seller might be upset about it, that, look, I want you to incentivize another broker working with a ready, willing, able, qualified buyer to do that. But Nevertheless, that is just in the GAR listing agreement. All right, what was the time limit to enter into FMLS? I believe, I might have it confused, but I believe it is 2 business days from the time a seller signs a seller brokerage agreement to put it in FMLS, and then 1 business day to make it active from the time of the marketing commencement date. And the issue is a registered listing is if it's going to be over 21 days before it's going to be active or coming soon. Outside of 21, Georgia MLS, I don't know. You will have to get Tanya. We'll have to talk about that later. Or just in general, just get with your broker. In commercial listing commissions, you've used at least X amount percentage to the listing broker, and on the co-op up to X amount selling broker. Could this be used in residential the same way? Sergio, that is a great question. And basically, so my answer is going to be check with your broker regarding their policies. But generally speaking, with the hierarchy of what takes precedence, a special stipulation does take precedence over pre-printed in the contract. So that is also true in a seller brokerage contract and a buyer brokerage contract. It's just the contract is between the broker and the seller and the broker and the buyer. So you could special stipulation out things like that as well. I'm a little bit hesitant in what I'm saying here because number one, if you're a realtor, you are still beholden to NAR Code of Ethics, and NAR has starting in 2020 and 2021, they are addressing these commission issues. So you would definitely want to, with clear cooperation and the MLS services, so you have to look, if you're a realtor, you have to check with the NAR. You need to look through those policies, and you need to look at the policies of the MLS services to which your brokers belong. So I think it needs to be clearly disclosed to another broker what they can reasonably expect for a commission for their service of being the procuring cause of sale for a buyer whom they are working with to come to that property. And again, Georgia buyers brokers get paid co-op. We're co-op, we're not sub-agents of the seller. So that's why it's more important because we're not sub-agents of the seller. So great question. So I'm hesitantly saying yes, ... as long as it meets the terms of NAR's policies, as long as it meets the terms of your broker's policies, and as long as it meets the terms of your broker's membership with that MLS service. Best thing to remember, disclose, 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 disclose. Because there's a lot of situations where, the buyer, an agent working with a buyer might still, as long as they disclose and know what to expect. The hard feelings and the issues come in when your expectation is here and the reality is there. If you know what to expect, we have a lot of buyers agents working with sellers, repeat sellers, and it's like, yeah, I'm just going to buy this little piece of land. I mean, the sale price is like $6,000. I'm not going to get paid a whole lot of commission. That's fine. I'm willing to do that because this is a buyer that's also going to buy this piece of land and this piece of land and this house or whatever. I mean, there's a lot of reasons, but you are a professional, and brokers and you guys do get paid for the valuable services that you bring to the situation, and you are licensed to do that. All right, let's see. And when a counter offer is signed, but the loan exhibit or lead-based paint is not, how should that be handled when the counter offer says signing? Okay. So the lead-based paint, hi Monica, the lead-based paint exhibit should be signed by the seller at the time of listing. And that has always been the case really per EPA. And now that has been made, that is spelled out in the 2022 listing agreement. You listing agents, you guys have got to make available the lead-based paint exhibit and the lead-based paint brochure, you buyer's agents, you need to make sure that you get those in the buyer's hands. But listing agents, make sure I would leave them on the counter in the house. I'd make them available through MLS services. Somehow, I don't know, Sergio, you're probably gonna know better than this. If you can make some of these documents available through showing time, something like that. So you listing agents, you've got to do any and everything you can to get that EPA lead-based paint disclosure into the hands of any and all potential buyers before they even see the property. Buyer's agents, make sure they sign it and get that brochure. So when you go under contract, here's the problem that we're having, because our lenders are not taking these classes. And the problem is, under the GAR counteroffer form, it does state, there's verbiage in there that states, okay, let me back up. A buyer signs an offer that gets initiated to a seller. If the seller is going to make a counteroffer, they don't sign that. They initiate a counteroffer. The seller signs the counteroffer and sends it back to the buyer. Let's not go back and forth. Let's just say the buyer accepts that. Now we only have one document that has both buyer and seller signatures on it, and that's the counteroffer form. So we have an initial offer that only has buyer signatures, and we have one counteroffer form that has both buyer and seller signatures. The counteroffer form states that the terms that are binding upon the parties for the purchase and sale of the property is everything that's in the original offer, including all exhibits and all special stipulations, except for what was changed or modified as written in the counteroffer. And only that counteroffer is signed by all parties because it references all the exhibits and all the special stipulations. So as brokers, as agents, as public people, we're good with that. However, our lenders freak out and they have a cow because for their underwriting, they need that loan contingency exhibit signed by the seller as well. And they're going to need that lead-based paint exhibit signed by the seller as well. Well, that lead-based paint exhibit in the buyer's initial offer should already be signed by the seller because the buyer should already have received it signed by the seller when they initiate the original offer. So that's a lead-based paint exhibit. That's a training issue to work with agents. If the lender needs a copy of that loan exhibit signed by the seller, my broker recommendation is that the buyer and seller execute a conformed copy or a clean copy. And don't go back and start initialing stuff from the original offer, because inevitably what's going to happen is accidentally, because of sending through e-sign programs or whatever, or the agent's not techy enough to separate them out or something, inevitably what could happen is the seller could sign the original offer. The seller never goes back and signs the original offer when they're binding on a counter offer, because you've got two binding contracts with two completely separate terms. So what I would suggest is doing a clean copy where you pull out a blank purchase and sale agreement, you write up the terms that were agreed upon, everything from the original offer plus whatever was changed. So if the sale price was changed by the counter, then in your clean copy under sale price, it's going to be the price that was agreed upon. I would do, Monica, a clean copy, because then the seller will sign the financing exhibits. And there is a GAR special stip at 622 that I would include that says all parties acknowledge this is a conformed or a clean copy. If there's any discrepancies between here and what was originally binding takes precedence. That's how I would address that. Now, that's my official formal broker and instructor answer. For savvy agents and techie agents, if there were no changes in the, I'm not even going to go there. I'm just going to leave it at that. The best way to handle that is by doing a conformed copy so that there are no mistakes and no issues with two binding copies. Let me make a quick comment on, so Deborah, you would not go back and have that exhibit signed because there is definitely the issue where the seller, if you can't tease out just that exhibit, there is a situation where a seller can go back and sign the original contract, and that's not right. It's just cleaner to do it that way. Additionally, we have issues all the time on that FHA loan contingency exhibit. There is a fill in the blank for the under the amendatory clause paragraph. So let's say a buyer writes an offer for $300,000 and they're getting an FHA loan, and on the amendatory clause paragraph 11 of the FHA loan contingency exhibit, it says $300. It's a fill in the blank with the dollar sign, so it calls for numbers, not words. You send it to the seller. The seller agrees to everything, but they're going to change the price to $350,000. So the seller fills out a counteroffer form. The only change is the sale price of $350,000. They send it back to the buyer. The buyer signs it and agrees. Now, appraisal gets done. We're under contract for $350,000. The appraisal comes in at $300,000. Is the buyer obligated to go through with the purchase? Yes, because the FHA loan contingency exhibit still said it must appraise for $300,000. It appraised for $300,000. There's no protection for the buyer, because in the counter offer, what should have happened, you're under contract for $350,000, but that dollar amount on the FHA loan exhibit never got countered. So they're still under contract for an appraisal price of $300,000, but the sale price is $350,000. What should have happened is when the seller made a counter offer for $350,000, and that was the only thing on the counter offer form, and the buyer agrees to that price, the buyer never should have signed that counter offer. The buyer should have sent one more counter offer that said, yep, sale price $300,000, and then special stipulation number 1. All parties agree that per paragraph 11 of FHA loan exhibit, the amendatory clause, the price must also appraise for $350,000. Then the seller would have signed it. Then if the appraisal came in at $300,000, then the buyer would not have been obligated to buy it. But because, and then it only happens on FHA, because FHA is the only exhibit between FHA and VA that has that fill in the blank for the dollar amount. VA just says reasonable amount as determined by VA. So that's why you don't necessarily go back and sign the exhibits, because that exhibit was incorrect. Again, check with your broker. There are ways of doing that, but best, cleanest way that I'm going to tell you as a broker and as an instructor is just to go ahead and do a clean copy. Anything else? All right. All right, everybody.
Dana, I got one quick question.
Yes, ma'am.
About the commission. So if someone is making their buyer obligated to make the difference in the commission, and you are showing a listing where the commission is not where you think it should be, and the buyer's going to make up the difference, don't you need to tell your buyer that in case they don't have money to bring to closing to make up the difference in commission? Because that commission would not be financed in their loan anymore, right? So they would have to make it up at the...
Yeah, they have to pay it. Yeah. So that's what that whole NAR DOJ issue is about. So
okay.
And that's why also they added the verbiage for 2022 in the buyer's brokerage agreement that, you know, the commission is listed in the MLS service, most generally speaking. So you buyers agents need to have a conversation with that. But like I said, Holly, you need to, if you're, I'm hesitant in saying, because I don't know what's going on with that antitrust lawsuit. And again, there's realtors policies on commission and there's MLS policies on commission from a seller side, what they're sharing. But that could be, let me put it this way, that could be an amendment of the buyer brokerage agreement between your broker and the buyer.
Okay, okay.
Regarding that. I think that would probably be a better way to handle it on a case-by-case situation.
Okay,
That would still not necessarily counter any of the NAR policies or get into any sort of antitrust issues. Great question. All right, anybody else? Thank you guys so much. I appreciate it. Y'all were my first class teaching it. So Monica, I tried to send it to you. It wouldn't go through too big. So I'm going to try to send it to you individually. But I'll email you a little bit later. All right, everybody. Now I'm going to stop the recording. Bye.